Hello, everybody. Hi. I didn't realize this wasn't set up. I was wondering, like, where the fuck is everybody? Like, where the fuck is everyone? And I'm like, oh wait, we're not done. This wasn't set up. So yeah, oopsie. Whoops a doodle there, guys. Sorry about that. I kind of thought everybody was gonna be here already, and I'm like, well, wait, where is everybody? And it's like I never created the stream. So Gene says, is there a verdict? I don't think so. If there is, don't say nothing because I don't know nothing about it yet. Just about that. Sure about that. So we are going to get to the rest of day 15. We aren't going to get any further than that because we will run into the 9 o'clock show. But I want you to guys know I was thinking about it, what our game plan is going to be. Tomorrow we will have time to plow through the rest of it. It's just going to take a little bit of work, but we can get through the rest of day 15. Now, as we left off, it was the defense's case in chief, and they are just beating the state senseless. I mean, they are just hammering the incompetency of the detectives involved. They are just relentless, and I think they're doing a phenomenal job. I guess today they had the charging conference for, jury instructions. Apparently didn't go so well for the state from what I've heard, but that's all I know at this point. So we are gonna finish up day 15 though, and, well, spread the good news. Spread the good news. Um, and now we are going to get this going. Remember, this is the afternoon part, and we have that crappy. Remember, this is the another detective where it's the Santa Cruz not my job department, because that's apparently the answer every member of the sheriff's department says. Not my job. That's not my job. That's not my job. This, what I'm doing here, is not my job. None of it's my job. Do I think he'll testify? I don't think he has to at this point. I don't think so. I don't think he has to. Um, Juror 13 saying no directed verdict. I think the judge is gonna, based on what I've seen so far, the judge is gonna hold this in his back pocket and stymie the jury if they screw up. But he would rather the jury make the right decision here. But let's get started and let's finish up day 15, the PM session.
All right, we're back on the record. The record will show that jury is absent, counsel is present, counsel are present, as well as the defendant. The court has reviewed state's proposed exhibits 143 and 144. 143 is a transcript of recorded interview with Miguel, who has been identified. 141. Did I?
Okay, you
Did I
said
make-
144. I just wanted to make sure we were
Oh, all
talking
right.
about the same thing.
Oh, thank you. Appreciate that. Law enforcement interview between Miguel and who were the other participants? Was that from the sheriff's office?
141 was Detective Barba and witness Ramon Felix Gonzalez.
All right. And 141 was, well, it says Aaron Felix Gonzalez.
It's Ramon Aron Felix Gonzalez, Your Honor.
And that was also with the sheriff's department.
Yes.
All right. State seeks to use these transcripts, play the recordings of the law enforcement interviews with these two witnesses. Neither of these two witnesses have ever been subject to cross-examination in any manner by the defense. Is that correct?
That's correct.
All right.
That's a big problem.
So state seeks to use these statements for the purposes of redirect or.
That's a major issue because these statements from people, their prior statements, if it had been in a deposition where the defense had a chance to confront them, that'd be one thing. This is unconfronted. These are unconfronted statements. There's a big confrontation issue there.
Or rebuttal evidence. Neither the court's going to sua sponte raise an issue. Neither of the parties has raised it to the objectionability of these two particular interviews. In Crawford versus Washington, 124 Supreme Court, 1334, United States Supreme Court, 2003. The United States Supreme Court looked at a situation, fact pattern.
Crawford is a major, it's not a landmark, I consider it a landmark in modern criminal procedure regarding the confrontation clause. So apparently nobody's brought that up yet, and I'm very concerned, but apparently the judge and I are on the same wavelength, chattel. Apparently judge and I are on the same page. Yes, confrontation clause for $2. Wombat Mommy says, today is my 16-year wedding anniversary. Well, congratulations. And here is to 16 more, at the very least. 32 more if you really like them. Or maybe just 16 if you kind of like them. It's up to you. Write your own adventure. Let's see what the judge is going to argue.
Nearly identical to this situation. The court ruled that it's a violation of defendant's Sixth Amendment right to cross-examination to admit hearsay statements, even if they're under a well-founded hearsay exception under the rules of evidence. It's a violation of a defendant's Sixth Amendment right to introduce hearsay statements that are testimonial in nature, that are offered for the truth of the matter asserted, because it's not subject to cross-examination. It's a Sixth Amendment question. It's constitutional. It's the same fact pattern as this. The witness in that case in Crawford from the United States Supreme Court case gave a statement to law enforcement officers that was incriminating of the defendant, and the prosecution sought to use that and did use that. The court ruled that that statement is testimonial. It's very clear from the case law, from the Crawford case and all case law that has discussed it since then, as a statement of this nature to law enforcement is testimonial in nature. It falls squarely within the Crawford decision. The use of this particular statements would violate the defendant's Sixth Amendment right to cross-examine confrontation of these two witnesses. It hasn't been raised. I'm raising it sua sponte because if the court were to allow this, and if there were a conviction, I have no idea what the jury's going to do. I'm not even speculating on that. But in the event that there were a conviction and the court will allow this, I think it's fundamental error that would result in a reversal and a remand back to this court. So for those reasons,
and he's right, very likely. Now I have a theory. These two don't give a shit. They're going to destroy whoever walks in the door. They're going to challenge whoever walks in the door. That evidence, these testimonies, these interviews and these statements, I'm sure show so much more confusion that there's going to be like a unicorn in the story. I'm sure these two are 100% fine with it. But yes, the judge is like, I'm not taking any chances. I'm not letting y'all fuck my case up. So we're nuking it.
And if the state wants to mark these and have these included as part of the court file but not exhibit, I'm happy to do so.
Yes, Judge, we'd like to do that. And that would be with exhibits 141.
And I still don't understand. Like, I want to make this part of the record. It's like, honey, you don't appeal anything.
142, 143.
Unless we go back to my original theory of they know they're worried about a directed verdict and they want to appeal that. But that's an abuse of discretion standard, and this would be well within his rights to do.
And I believe we have the 911 calls marked too, Your Honor. But before I get to that, now I'll give you.
What's 142?
It's the actual recording that the state intended to play.
Okay.
That we have synced to the transcript. We also have the 911 calls, which we would have requested to play as well. I'll get to that in a minute. But with response to the confrontation clause issue, Your Honor, that was directly addressed in the Praser-Fong case. And what the court said in that case, first of all, the state's not offering the statement itself for the truth of the matter asserted. We're offering the statement for the purpose of rebutting the defense's argument that the law enforcement officer's investigation was inadequate. That's the reason they indicated they offered them, for two reasons. Because they believed they were false, and because the state's investigation was inadequate. And so that's directly on point with the Escalante Orozco case and directly on point with the Prazerfong case. And what the Prazerfong case says is that when the defense offered part of the statement, they waived the confrontation clause issue. And that case is a 2005 case in Arizona, Your Honor. And so for that reason, the state believes that the statements should be admissible. And I'll get the other
Exhibit numbers.
number.
All right, well, I have 141 and 143. I'll give these to the clerk. These are not admitted exhibits, just to be clear, and they're to be made part of the court file
And I have
for whatever
142.
purpose.
I have 142 here also, Your Honor.
Very well. But
Are we making that part of the record as
These were interview statements and interview transcripts of parties that were never cross-examined or challenged by the defense. Of, I don't know who exactly these people were going to be, but the things they were going to try to use on rebuttal, the judge is like, we ain't playing that game today.
well, just for the record?
that's the recording itself.
Yes.
142 can be made part of the record, but not
Thank
admitted.
you. And I'll find the recording for the 911 and let the court know what that is so we can make that part of the record. As
Which
well.
911 call is that?
They're all the dispatch calls with the individual known as, who identified himself as Miguel.
Oh, right. All right. But I mean, obviously, clearly that if either of these witnesses were here and subject to being called and
Okay, I got to answer this question. So, Philip, I don't think I'll ever stand not offer for the truth of the matter. So you're going to imply it's true instead of saying it is. That's the same fact. Okay. Yes, there's times where I can offer a statement, not for the truth of what's asserted. And there's actually in law school, you learn about a very famous case. So this is like in the 70s, and a plane crashes, a small private little airplane, and it's flown by like a rich millionaire. And it's him and his wife. And the issue is who died first, because who died first determined how the money went in the family based on the will. So if the wife survived the husband, it went to her family. If he survived her, it stayed with his. So the plane crashes and a police officer gets there. And it's like pouring rain, and the plane had crashed. And he gets up to it, and the guy is alive. And how does he know the guy's alive? The guy starts speaking to him. The wife is dead. She's like, her head's missing or something. She's clearly dead. The wife's attorneys and families are arguing, wait, that's hearsay. It's an out-of-court statement to prove the truth of the matter asserted. And that's not the point. The point is, he was speaking, and if he's speaking, therefore he is alive. Because when it went to trial, they said, you encountered the gentleman flying the airplane, right? Did he speak to you? Yeah. Objection, hearsay. No, I'm not asking. And you hear this here routinely. Don't tell me what he said, but did you speak to that person? Yes. And that's how you lay foundation for that person then coming in and talking about what happened. The detective, you spoke to this witness, right? Or, ma'am, you spoke to so-and-so, right? Yes. I'm not asking you to say what happened. I'm asking you to prove that words were spoken. So, yes, there are other times, though, yes, where the not offered for the truth of the matter does get heavily abused, but that's like the most basic version of it. And I just wanted to make sure you guys understand there is a reason for all this, and the hearsay rules are what they are. This is hundreds of years in the making. So that's the other issue. I mean, Sir Walter Raleigh was convicted and sentenced to death on hearsay, and that's the reason why we have rules against hearsay. So I guess I just kind of start with that one, get going. This case should have never been charged in the first place. I agree, Roy, but the state had the wrong impression and they didn't want to back down, I don't think. So that happens. Let's keep going.
subject to being cross-examined live in court, it would be a different thing because they'd be subject to cross-examination. Obviously, they're not here. I'm sure they're not here. One of them, both of them are
Right, but the
parts
problem,
unknown. So,
right, but the problem is the defense offered the pieces of their statements that they wanted to offer. The state was never able to rebut that, and then claimed the investigation was inadequate, and the state didn't get an adequate opportunity to rebut that. That's the state's argument. That's why we're arguing we're prejudiced in this case.
free to argue it, make your record, appreciate that. But I feel that this is a very clear to admit these particular recordings of statements by these witnesses.
And that's a fair argument by the state. They're saying, look, Pancho and Sancho, the defense keeps hammering that they interviewed these like fucking randos and they gave you different accounts, right? Well, the state is actually trying to make a valid argument saying, well, I want to bring in that statement from Pancho and Sancho. And that's not typically an unfair argument. The issue is, though, the defense has never had a chance. They never got a deposition. There was never a prior hearing where Pancho and Sancho came in where they could challenge this, and they've had the chance to cross-examine them. That's the problem here. There's no confrontation because you can't confront a transcript. It just says what it says, and therefore it can't be contradicted. So it was good work by these two, knowing these guys couldn't come in. If I were them, I really would have hammered on the idea that these two, I don't think did a good enough job at trying to preclude that. But I don't know if that would have been precludable. I think the judge would have let it in anyway. I'm not sure how they would have done it if I were them. I just don't think they did a good enough job protecting their six.
We're not here, not subject to cross-examination, and therefore we're not able to fulfill and accord satisfaction to the defendant's Sixth Amendment right to cross-examine and question these witnesses. And I've read these statements, and they contain a lot of information that is highly prejudicial. And for whatever purpose, if they're not offered for the truth of the matter, sir, I think it's even a larger violation of the defendant's Sixth Amendment right to permit that to be done. But you made your record, court's ruled, I'm not going to permit those two recordings to be played, given the Crawford case and the Sixth Amendment analysis that the court's applied to the case.
Your Honor, and the other exhibit number is Exhibit 144, if that could be made part of the record as well.
So granted, so ordered. Okay. So, Mr. Jetty, you spoke before, so where does that leave us?
The state rests, Your Honor. No rebuttal witnesses, Your Honor.
Very well. So what we're going to do is I'm going to bring in the jurors, the state can rest, and then I'm going to tell the jurors we're going to need, I would estimate about an hour to finalize final jury instructions, get them copied and printed out. We'll come back, I'll give final jury instructions. That'll probably take, I don't know, well, what do you think, Denise, about 45 minutes? 45 minutes at the most. And then we will probably recess for the afternoon, come back tomorrow for closing arguments. Counsel, the court's going to limit time and closing argument to 90 minutes per each side. That should be plenty of time. And the state will have 90 minutes as well. The state can watch the clock and reserve whatever time from the 90 minutes for you think might be necessary.
More than enough. 90 minutes is more than enough.
Your Honor, I think since we have the burden, I'd ask that we have additional time for rebuttal. That would be our request.
All right, I'll take that into consideration.
Thank you.
You're welcome. All right.
We need more time. He's got. I'll think about it. He's gonna come in tomorrow and say, nope. We need more time. You have 90 minutes. This isn't fucking OJ. This is easy. Remember, they're playing on easy mode too. And the only reason why they're upset is because now the road's getting a little bumpy.
All right, let's anyway, that's the plan. Let's bring in the jurors, please.
And Your Honor, I think the further record on that is that this has been a 4-week trial. I don't think that 90 minutes is adequate to cover.
Well, I think this jury has had the facts presented to them. The jury has had the facts presented to them, and they understand what the facts are. I think it's more about arguing the facts and how they apply to the law. I mean, all of the salient facts have been produced and repetitively. So let's just leave it at that. Not to mention the fact that the parties had opening statements that were somewhere between an hour and a half and 2 hours each, which basically laid out the entire case in the beginning.
Yeah. You already had your shot.
He's right.
So it sounds like they're going to be done today, chat. Sounds like we're watching the finale of the trial.
Please be seated. The record will show the presence of all the jurors, counsel, and the defendant. Good afternoon, ladies and gentlemen. Let me tell you where we are, what's going on, and what's going to happen next. Well, first, I'm sorry. Does the state wish to present any evidence in rebuttal?
No, Your Honor, the state rests.
Okay, state's rested. What does that mean? All the evidence is now in. State's presented its case in chief. The defense has presented its case. The state is not going to present any rebuttal case in chief.
Oh, wait. Oh, defense is resting? I didn't hear them say that. Did you guys hear the defense saying they were resting? Truck golfer says, is this guy free? Yep, he is out on bond. He's out your way. Go, well, don't go knock on his door. He might fucking shoot you. But he might, he bro out with you. He said the state, but I think he said we're all done here. Yeah, yeah. So here we go.
Counsel and the defendant. Good afternoon, ladies and gentlemen. Let me tell you where we are, what's going on, and what's going to happen next. Well, first, I'm sorry. Does the state wish to present any evidence in rebuttal?
No, Your Honor, the state rests.
The state is presenting evidence to rebuttal. We didn't go through George Kelly. The state, okay, they're done. I didn't hear them say they're done. What the fuck?
Okay, state's rested. What does that mean? All the evidence is now in. State's presented its case in chief. The defense has presented its case. The state is not going to present any rebuttal case in chief. All the evidence is in. So what I need to do now is meet with the lawyers. We didn't do it over the lunch hour. We took a break. I need to meet with the lawyers. We need to finalize the final jury instructions. We've already been working on it. They have drafts and they've reviewed them. We've been working on them. Once again, so I'm gonna have to send you out, but I'm explaining why. Because this is, again, something I can't do with the lawyers until everyone's rested and all the facts are in. Couldn't do it before. We kind of started the process.
Yeah,
the drafts of the jury instructions, but now we've got to review it.
I don't think that the defense formally rested, but it sounds like they're like, yeah, I think they may have done that off the record. But yeah, that's it, chat. All right, well, ding ding, the bell's done. We're getting ready for the judges' decisions. Let's see where we're at. Did Kelly say they were done yesterday? I don't think so. Chat rest too. Aw. Guys don't want to feel left out. Yes, stay for a bell and they declined. Yep. Did Kelly say they were done yesterday? I didn't hear it. But they beat that ass yesterday.
To make final instructions. We'll have Jose here in the courtroom. We'll make those changes. He's been warming up his fingers. So that gets done efficiently. And once that's done, we'll copy them off. You'll come back in and I'll read you the final instructions just the way I did the preliminary instructions. Then given the hour, what we'll probably do is recess for the day. We'll come back tomorrow at 8:30. And when we begin at 8:30, we'll begin closing arguments by the parties. And following the closing arguments, I'll give you some very brief final jury instructions about what to do when you go back there. And at that time, we'll pick the 4 alternates, assuming we still have all 12 jurors, and then you'll begin your deliberations. So the case will be submitted to you, likely for deliberations tomorrow afternoon. So I need to meet with the lawyers. So what I need to do, I'm sorry, we got a little bit of a gap here in time where you're going to be waiting in the jury room. It should take about an hour. Again, couldn't get it done before this moment, so apologies there, but we'll be in here working. I'm going to excuse you. Any questions about any of that, folks? Yes, ma'am. Allergies, sorry. What happens to the alternates is, yes, they do not participate in the deliberations. And I'll explain, but since you asked, that's okay. The alternates will leave. They will not participate in the deliberations. The alternates, however, will not be reduced from the court's admonition to not talk about the case unless and until a verdict has come in. The reason for that is that in case there are going to be 8 persons who are going to end up deliberating, in case any of those 8 persons who are actually deliberating cannot complete the deliberation process. Maybe somebody gets sick or they have a family emergency and there's a deliberation and they can't complete it. What will happen then is we'll draw a name from one of those 4 alternates, and that alternate will come in and substitute in and be part of the jury deliberation process. Once a verdict has been rendered, we'll call whoever the alternates are and tell them case is over. We'll tell them what the verdict is and that they're released from the admonition. So you're not really, if you're an alternate, you're not really released from the jury service until we call you and tell you that there's a verdict that's come in for that reason. And that does happen. Sometimes people, for whatever reason, can't complete the deliberation and we got to substitute somebody in. So that's what will happen.
It does happen.
All right. So I'm going to excuse you. Please wait in the jury room, hopefully about an hour, and then we'll come back and we'll do final jury instructions. Any other questions? Good. All right, you're excused until further notice, and I'll stay here with counsel and we'll work on the jury instructions.
Please rise, por favor.
Excuse me. I need the most recent findings. Yeah. Just get somebody else to do it. All right, have a seat. I'm sorry. All right, to the public and the media, we have a legal discussion here about the proposed jury instructions. We do it off the record, and then we go on the record to preserve final objections that the parties may have. You're welcome to stay. You're welcome to go as well. This is usually not one of the more interesting parts about the process, but if you're interested, thank you. You're welcome to stay. And as I said, I told the jury it should take about 45 minutes or an hour to get this done. So we will we go off the record for purposes of the court reporter for now, and you're welcome to keep the camera running. You're welcome to stay, but fair warning if you do. Okay. Okay. We got Jose. We have counsel, and we have the proposed instructions.
Your Honor, may I ask a question?
Yes, ma'am.
Can we all participate or
Yes.
only one speaker?
You can all participate.
Thank you,
It's
sir.
very informal.
Thank you.
Thank you for asking. Okay. The first several pages are all standard instructions.
Can I
I know there was
have a
this-
concern about the first page?
Okay.
And I know that I'm coming from a different jurisdiction, but I do have a issue with the fact that the jury is required to determine what actually happened. If we were to give them that instruction, then because of the uncertainty of a lot of facts in this case, they will be deliberating a long time trying to figure out who did what and trying to solve the case, which I don't think anyone can, in my personal opinion. And I feel like it's not the right burden.
I agree with you. Actually, no one's ever brought that up before.
Thank you.
Uh,
She looked at me really weird. I'm just kidding.
No, yeah, it's usually, but no, their job isn't to determine what happened. Their job is to determine what the facts are. So
Thank
it
you,
said
sir.
we can change that to you as jurors are the sole judges of the facts.
Yes, sir.
Okay.
Yeah, that's how it should be.
Are you with us, Jose?
I don't know where we are, Your Honor.
First page.
Page 1.
Yeah, page
Judy
one, like
Abduri.
right there.
Is this not the Raji?
It is, but she makes a good point. So Raji recommended, and I think she makes a good point.
I would object. I'd ask that we use the Raji that we've used for decades.
Understood. Raji are, I think they're recommended. I think that's what the R stands for.
Recommended,
so-
but they're not
or maybe it's
mandatory.
revised. I don't know. Anyway, are you with us there? So it's the end of the second paragraph. You as jurors are the sole judges of the facts.
And actually, the first sentence of that second paragraph also says you have to determine what actually happened.
Okay,
Same objection, Your Honor.
noted. So look at the second paragraph, the first sentence. It is your duty to determine what the facts are in the case by determining the facts instead of take out what actually happened. And then the same thing at the last sentence of that paragraph.
I don't even think that first sentence makes sense, Your Honor.
I think if we just cut it off, I think if that
Yeah,
first
what the
sentence,
facts
of the second
are.
paragraph,
Okay.
it is your duty to determine what the facts are in the case, period.
Good, okay. So that sentence, it is your duty to determine what the facts are in the case, period. Okay, got that? Good, all right. Anything else, let's say through pages 5?
And I was wondering in that, just on that same page, it just might be a little bit better, but not mandatory, but the last paragraph, the second sentence, as you determine, I just wanted to know if the court would consider review the facts.
We're on.
Pardon?
I think it's fine the way. it is.
Okay, that's fine. I'm
It doesn't,
okay.
it doesn't change the content the way
Yes,
your
sir.
other,
I have no,
the meaning the way your other suggestions,
thank you for listening.
of course. So let's see, through page 6, 7, or any, stop me if you, I know we had 2 different instructions here depending upon whether the defendant was going to testify or not testify.
Judge, and I think burden of proof.
I don't-
I'm not sure if council's asking for the second half of that.
Tell
On
me
page
tell me what
10,
page you're on.
I don't know.
4.
If we, did we? Oh, we're on page 4. I got too far ahead.
What's the question about page 4?
I think this is 2 instructions in one. Is council asking for both? I don't care. I just want to make sure the record's clear.
So
Yeah,
we,
I'm asking for the whole thing.
all right, there's 2 different instructions on burden of proof, but we'll give them both.
Fine.
All right. Stipulations, redactions.
I don't recall if we had any stipulations, so I don't know if we need
We didn't, Your Honor.
the stipulation.
That's page 10.
Yes.
So Jose, we can just take all of page 10 out, that whole instruction stipulation. Agreed?
Yes. I also don't know if we have redacted exhibits.
We do. The text messages.
Oh, okay.
All right, so we'll leave page 11 in.
And then I think just defendant's testimony needs to come out.
So defense, I assume you want us to leave? Well, I don't want to make any assumptions. Page 16, defendant need not testify. Do you want
Leave
that?
that in, yes.
Leave that in. Okay, sometimes people don't. And then we'll take out, so Jose, we're on page 17.
Why would you not
That'll
want
come
that?
out.
What?
Defendants,
Why the hell would you not want that in? You need to. I assume you as jurors are morons, and I need to make it clear he doesn't have to.
must evaluate the defendant's testimony the same as any witnesses, right? That comes out, he didn't testify. Right?
Correct.
Okay. 18 stays in, correct?
Oh, yeah, that's right. It's his statements. He came through.
Yes.
Yes.
Correct. Witness's prior conviction, cooperating witness had a prior conviction, correct?
Yes.
So I'm assuming the state wants that in there.
Yes, Your Honor, they did.
That's page 19, so that stays in. All right, now, is there anything before that? I'm looking at page 20. There's
We don't have
some,
page numbers.
We don't
What's
have
the
page
heading?
numbers,
What's the heading?
evidence for a limited purpose.
I think we wanted one out and the other one in.
right? I think this would both deal with the text messages, so I would prefer the next instruction on other acts.
Your Honor, I think we need evidence for a limited purpose for multiple reasons. Detective Barba's testimony regarding all of the other witnesses, the court allowed that only for the limited purpose of determining whether their investigation was appropriate. In addition, there were 9 photographs that were photo lineup that were admitted only for the purpose of determining whether law enforcement did an appropriate investigation. In addition, Your Honor, there was the impeachment of Detective Raul Rodriguez that, again, was only offered for the limited purpose of determining whether the investigation was appropriate. They were not offered for the truth of the matter asserted. Those are very important instructions for the state.
But I think there was a number of times I gave limiting instructions on hearsay and otherwise, so.
So what
Yeah,
do you fill in?
So here's what, let me tell you the language I propose to use, okay? So I think we do need the instruction. During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose that the court stated at that time.
Judge, and I don't think you gave that limiting instruction with Detective Rodriguez, and I would ask that we are specific with the jury. I think the jury needs an instruction in the back reminding them of the limiting instructions. I would ask for that with respect to all
So
of
this
those
is-
issues.
Well, I mean, I gave limiting instructions. We just reviewed some of them. You did as well,
Mhm.
in a number of different contexts and different types of limiting instructions, hearsay and the other things. I don't want to confuse the jury or give them excessive information by going through each and every example or situation where the court gave a limiting instruction. You can argue that to the jury if a limiting instruction was or was not given with respect to certain evidence.
And
But,
Your
but
Honor,
I'm not, what are you asking me to do, to give an instruction that I did not give a limiting instruction when for Detective Rodriguez?
I'm asking you to clarify for the jury what the purposes of the limiting instructions were, specifically with Detective Barba and Detective Rodriguez. I think they need that in writing specifically, and I believe it's very important for the state's case that we make it clear that that testimony was only for the purpose of determining whether the investigation was appropriate. And I don't think the court gave the limiting instruction during Detective Rodriguez's testimony. And so I believe that's extremely important with respect to Detective Rodriguez's testimony.
If I didn't give it, no one asked for it. I'm not going to do that. You can state your objection on the record. I think that's more information, more detail than is appropriate for a jury instruction in a case such as this 4-week trial, numerous different types of limiting instructions. You're welcome to argue to the jury the court gave you a limiting instruction or didn't give you a limiting instruction as to a particular testimony. And when you argue the case, place it in that context for the jury. But I mean, I guess I haven't heard from the defense. Do you have any objection to the language as proposed?
No, that was good, Judge.
Right. And again, you'll be able to, when we go on the record, both parties will be able to make formal instructions. All right, so Jose, I'll give this to you when we break, okay?
There's Jose and Jose B.
And you still want the other act. Oh yeah, we kind of run out of page numbers. You still want the next instruction, which is other acts, correct?
I think that only applies to the text messages, but give us 1 sec, Judge.
Sure.
Uh-oh, they're talking.
Could
Everybody's
you reread
talking,
one more time
talking
what you're
at
proposing on the other one?
me.
course.
Limiting instruction.
Evidence for a limited purpose. During the trial, the court admitted evidence for a limited purpose. In connection with that evidence, the court gave you a limiting instruction. That evidence was admitted only for the limited purpose that the court stated at the time.
Judge, I don't think we need this one since you already provided that one. I was just thinking of the text messages, but I think during trial you provided a limiting instruction regarding those as well.
You're talking about the other acts instruction?
Yes, so I think we could take that out.
State's position?
On the other acts evidence?
on the other acts instruction?
No, I think it needs to come in as well. I think they both need to come in.
All right, I think the other act, I'll give the other acts instruction. If you want to make an objection to that, then you can when we go back on the record. All right, separate counts. Then then there's a couple of final instructions, the jury foreperson in closing.
Judge, there's one before that the state's requesting, and that's standard instruction 44, which is the motive instruction. I didn't see that the court included that, and I would like the motive instruction added. I can email it to your JAA if you'd like.
What's the defense position?
We're okay with that, Judge.
All right, if it's fine, then no objection by either side, I'll give it. If you'll email that to Jose. It's very
Once
short.
we read it, of course. We like to read it too.
Sure, it's really short.
I'll
Well,
include
email
the defense, of course, as I'm ethically required to.
Okay. So what I was then saying is we go into, these need to be just reorganized. There's some closing instructions, and we'll take those out, and those will go, I'll read those, thing about the jury foreperson and the closing instruction. I'll read that after your closing arguments. So then we're going to go to the statutory definition of the elements. So I'm looking at the first one that says second-degree murder.
It's this packet, right? Judge, the only thing we had on that were some punctuation issues. And it looks like the new second-degree murder, I think it now has some brackets. I'm looking at page 33. Is that what the court's looking at?
No, I'm just looking at the one that says second-degree murder. The crime of second-degree murder requires proof of any of the following. It just says the elements. There's no
Your Honor, I would have had knowingly under number 2 instead of new, but that may be just your state. I don't know. But everything is intentionally, knowingly, or they're all recklessly. And that one just says no. I just thought knowingly would fit better.
And Judge, I think this tracks the statute.
Yeah, I think so too.
Okay, and that's something I'm not aware of.
That's fine.
And
All
Your Honor, we got a new set from the JAA for the end of your jury instructions. So I think they've been redone already. And he included some bracketed
I know.
language as well.
We're gonna get to that.
Okay, but
But
it's
the one
same
that I have, the
instruction.
second-degree murder, is just the Raji, just from the,
Right, but
it's got 1 or 2 or 3.
it's the same instruction. It's just later in your packet. It's the exact same instruction. It just has additional bracketed language.
Oh, yeah. Let me see. All right, what do I?
It's on page 33 of what Jose gave us.
Yeah, but I understand. It looks like I'm looking at something different.
Because I just want to make sure we were all on the same page.
Jose, I don't think I don't have that in this thing you just gave me.
Which one? 33 is over there. We haven't gotten there yet. Get a clean copy. This is just. You can look at this one.
Okay.
Guys, I'm not going to skip through these parts. I think it's important to hear what they're talking about.
See what's going on here.
And I sent that instruction to Jose, so he should be getting it in there.
Motive instruction.
Yeah, the motive one.
Yep, we're going to be talking jury instructions right now. I think it's important to listen. I think this is actually going to be important. Sounds like they get their ass kicked here.
All right, I see what you're talking about.
It's only an hour long anyway, chat, so.
I don't know what the difference is. Oh, it just substitutes the initials of the deceased, right, for another person.
Yes, Judge, and there were some typos and some
What about-
formatting issues as well.
What about
with
the
first
one? What about the first one that has GCB?
I think we could put Gabriel's name in there, Gabriel Cuen-Buitimea. I don't think it needs to say of another person. So I think putting the victim's name in is appropriate. And then there's
Defendant caused the crime of second-degree murder requires proof of one of the following: defendant intentionally caused the death of GCB, or
We're at 1.3
defendant caused the
speed.
death of GCB by conduct which the defendant knew would cause death or serious physical injury, or under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of GCB. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. I mean, that seems That's the instruction.
Yes, I don't have any objection to the instruction, Your Honor, just some formatting issues. I just wanted to bring to the court's attention that we had this twice
Okay,
in the
good.
packet you sent.
All right, so that one's okay.
Just that I would ask that we move the or up to the first line and that we would put a semicolon in the second line, at the end of the second line, the number 2.
All right. I'll go over that with Jose. We'll go over that later.
And then there should be a period at the end of number 3.
Okay.
That was all I had on that one.
All right. What about the next page, aggravated assault?
Your Honor, I feel like we left out the name of the victim in this, and I propose that we put it at the end of number 2. The assault was aggravated by the following factor: the defendant used a deadly weapon or dangerous instrument against, and then the victim's name. Nowhere in there are we identifying the victim. So the jurors will be confused. Which one's the victim in this one?
Okay.
I don't have an objection. I would add it to number 1, Your Honor. The defendant committed an assault on Daniel Ramirez.
But it's and.
On Daniel Ramirez, and the assault was aggravated by the following factor: the defendant used a deadly weapon or dangerous instrument. And then also under the assault definition,
Hold on, let's get to, how about that defense? The defendant committed an assault on Daniel Ramirez, comma, and, does that work?
And the assault.
I'm just kind of off the top of my head, I'm just thinking, it seems there needs to be something to explain to the jury that he would have to use the deadly weapon or dangerous instrument against that particular person in order for that to be.
How about the defendant used a deadly weapon or dangerous instrument during the assault?
I don't have an objection to that, Your Honor. I don't think it tracks the statute. I think it's unnecessary, but I think adding on Daniel Ramirez is fine. And I also think,
Adding Daniel Ramirez, I mean, I take your point that it's, so they're not confused about who the victim was in that particular charge. But,
Right.
Can we
All
put
right.
the name in both?
all right,
and Your Honor, I think we could add it again down in the assault. I would ask that we not add it to the deadly weapon portion, but intentionally put, instead of another person, we could say Daniel Ramirez.
So what I'll say is then, under it says assault, the crime of assault requires proof that the defendant intentionally put another person, and then I'm going to put in parentheses, Daniel Ramirez, in reasonable apprehension of imminent physical injury. Okay?
Yes.
Then we have definitions: knowingly, intentionally, intent, recklessly, reckless disregard. Those are all,
And I'm sorry to go back, but I don't think we ever cleared up whether we were going to use Gabriel's full name in the second degree murder. The state is requesting that we use his full name, Gabriel Cuen-Buitimea, instead of the initials.
I leave that to the court.
okay, full name. All right, and we'll go over these. Jose, we're going to go over these.
And if, just to be consistent, if we're going to use full names, when we go back to the aggravated assault, we'd ask for Daniel Ramirez Ruiz, AKA Daniel.
See, this is what starts to happen, okay?
Well,
And we're trying to get this done so we don't keep these people waiting here all afternoon for changes in semicolons and stuff like that. If there's something really substantive, let's raise it. Otherwise, I really don't want to hear it. You know, if it's something that substantively changes, the actual instruction clarifies it in some way, but, you know, we're not going to, a lot of this is, I just put Daniel Ramirez and we'll do that. It's just to make sure there's no confusion between the two victims. All right, if you want to make an objection on that, you can do it. All right, so then we go into the definitions. Those are all standard. Anything
We're
else?
missing physical force, the physical force definition. We have deadly physical force, but we don't have physical force.
All right, do you have that? We send it to,
I do, Judge.
send that to Jose, send it to defense counsel. It is in there? Where
I
is
see
that?
physical injury, but I don't see physical force.
Oh, yeah, it is up there.
Where is it?
It's on the top of the next page. Yeah.
Where?
After,
page?
That's not a definition. That's actually the instruction on justification.
what's in the one I have?
Oh,
Definition of deadly physical force. Deadly physical force means either force which is used for the purpose of causing death or.
right. It's not the deadly physical force we're missing.
Yeah.
It's physical force
Oh,
we're
physical.
missing.
Oh, I got you.
I will say in defense, there ain't nothing he could do right now. This is like when you went to work with your parents and you sit at the corner of the fucking desk. Like, there's nothing for you to do. This is out of his hands now. This is the lawyer time. We're past the cop making shit up time. We're now the lawyer's bullshitting segment of the program. So he literally can't talk about shit right now. And I will tell you this much: if I was a prosecutor and I'm sitting there doing work and the cop I'm working with leans in there and tries to tell me, hey, you should, I'd be like, who the fuck are you right now? I'm busy. I might say it a lot nicer than that, but I'd be like, I'm working. I got this.
So would you like me to email that one?
Yes. Okay, so we need physical force came to email. All right, now then, anything else about the definitions?
Hi, Hella.
Until we
How are
get
you?
to causation, ignorance of fact. So the
I
next,
don't think
the
dangerous
next
offense,
series, what's that?
I don't think dangerous offense should be here, Judge. That's for the aggravation phase.
Yeah, I agree.
Oh, okay,
So that one needs to come out.
thank you. All right, out. Good. So the next series of instructions are all defense requested instructions concerning justification.
I've sent the physical force instruction, Your Honor.
Thank you. These are all defense instructions. There's one line to be filled in. I'm not sure what that is.
Is the causation, ignorance of fact, is that a Raji? I'm not familiar with that one.
I don't think we need it. Yeah, I don't know that we need the causation or ignorance of fact. I'm not sure why that's in there.
These are, if you don't want it, these are ones that you.
Yeah,
suggest-
we can take that one out.
All right, causation, ignorance of fact, we'll
Hmm.
take that out.
And they're like, yeah, we're cool with waiving stuff.
And Your Honor, I think so for the justification use of physical force, I don't think that one applies because I don't think there was physical force used in this case. If you look at the definition of physical force, what it says, this is the instruction I just sent to everyone. It means force used upon or directed toward the body of another person and includes confinement, but does not include deadly physical force. I don't think there's any facts in this case that Mr. Kelly physically assaulted anyone, so I don't think that definition comes in. It's duplicative of the deadly physical force one, and that one is the one that I think is applicable.
And Judge, I would just say that if Mr. Kelly is firing up into the air to try to scare people off of his property, then he is using physical force. He's not using deadly physical force. He's threatening deadly physical force, arguably, and also using physical force.
That's not physical
Well,
force.
let me say, I've read a lot of case law on jury instructions for justification and self-defense. And they consistently say that if there's, I think the word they use is a scintilla of evidence to support the defense, the court's got to give the instructions. So I'm going to give that instruction.
I just haven't heard what the scintilla is, Judge. That's the only thing I'm looking for is we have a defendant who shot his gun in the air. It's either threatened use of deadly force or deadly force, depending on whether you believe he shot it in the air or whether he shot it at them.
Got it. You can make your objection, formal objection when we
Okay.
get to it. What about the rest of these? These are defense requested instructions. Do you want these instructions?
Judge, and I would argue that
Can I hear from the defense, please,
oh,
first?
sure.
Yes, Judge, we want justification for self-defense, justification for self-defense involving physical force, and justification for defense of a third person, justification in defense of premises.
And that one, I'm just going to stop you. I don't know what, there's a blank there. I'm not sure what that was. Do you know what that was? Justification in defense of premises. It's, I don't know page numbers anymore, but it's in the middle of it's the bottom half of one of the pages. And the first line, there's just a blank.
What?
It was a bracket that I needed to add by the blank. I didn't know what certain brackets that I did in there.
Oh, you have those? All right. What does it say? What's in the brackets?
Threatening to use deadly force, deadly physical force, and using physical force, and attempting to use physical force, and threatening to use physical force.
Just kind of approach, I can just give you my copy.
Yeah, that'd be helpful. I appreciate that. I don't know why it's difficult to work off the same, different pages. Thanks. Thank you. All right, I got you.
And Judge, I would like to talk about the third person one as well before I know you're looking at this one right now, but I would
The
like
third
to
person
discuss that one.
is his wife.
Yeah, Judge, but she's inside the house. There's no indication that anyone ever threatened her. So there's no defense of a third person here.
Oh.
She's inside the house. No one ever pointed a gun at her. No one ever pointed a gun at anyone.
Well, the case law, as I said any scintilla of evidence. I don't know what a scintilla is, but it's probably one half step above microscopic. I'm not going to commit error by not giving instruction if there's any evidence to support the instruction. That's what the case law says. That's what I'm going to follow.
What are you worried
What
about?
about on this
Error in
justification
this
of defense of
situation. Come
premises?
on, man.
There's some bracketed in there. We've got to select.
Error that
One
benefits the defendant. Come on.
Judge, I'm on 31.
Oh, right. You're right.
That needs to be fixed.
And Judge, as to this one, this is completely inappropriate. There's currently legislation pending because the legislature recognized that this justification defense does not apply in this case. The reason is because it requires that the offense occur on the premises, which is defined as the residence.
Your Honor,
wait.
that legislation that she's referring is just purely castle doctrine on shifting the burden of proof. It has nothing to do with giving the ability to shoot someone out in the property like a lot of the media is saying.
Well,
It's a castle doctrine.
Was there legislation pending?
Yeah, Judge, and obviously counsel hasn't looked at the legislation because the
I-
legislation
It's not law.
specifically
It's not
changes.
law.
Right, Judge, but what I'm saying is the reason why the legislature is changing it is because they recognize that this justification does not apply in this specific case.
Well, they haven't changed it yet, and the governor hasn't signed it.
I'm not saying that, Your Honor. I'm saying this one doesn't apply here because it's the definition of premises in the statute, which has been left out of the version that defense counsel provided. The definition of premises includes that it has to also include a house. So they have to be trying to get into a house in order for this justification defense to apply.
And Your Honor, to remind you that the threat came to them while they were in their home.
Well, to me, that's a scintilla.
Premises, just, I had,
And Your
All
Honor,
right, all right. We're bouncing around too much. Part of it is my fault because I'm working off a different draft. Let's look above that on page 31. Ms. Lothar points out, says physical force, there's some brackets there. The brackets mean there's alternative language that can be used in the instruction. What is let's go through this more systematically. What is the defense position on which of those elements should be used that is bracketed?
I'm sorry, where are we?
Right here.
Page 31,
Okay.
physical force was necessary to protect another's use, attempted use, apparent attempted use, or threatened use of physical force against a third person.
I think we might need more than one of those. So could we do or? So physical force was necessary to protect against another's, I would say
Yes.
certainly attempted use or apparent attempted use or threatened use. Well, actually, I think we need use too. I think we need all of those. We just put an or of unlawful physical force against a third person.
Your Honor, obviously, we're going to continue to argue that there was no use of force, there was no attempted use of force, there was no apparent attempted use of force, there was no threatened use of physical force in this case, specifically with respect to physical force, under any scintilla of any facts.
We have evidence that was reported by law enforcement officers that Mr. Kelly said he was shot at. Now, you don't agree with that, whether it's proof or not, but I mean, if there's evidence in the record that the defendant, that the jury heard that the defendant says he was shot at.
And then 6 minutes later, he said, I don't know, wasn't shot at. It was from another direction. I don't know what direction it came from. And then when he talked to Detective Ainsa, he said, no, I don't know where the shot came from. And he's inside his house. So that he's not shot at, he's inside his house. On all of the fact scenarios, he says he's inside his house.
Can he be shot inside his house? I mean,
Yes.
Ms. Hunley, I understand what you're saying, but I'm dealing with case law from Supreme Court of the State of Arizona, Court of Appeals of the State of Arizona that says if there's any, I mean, the case law is clear.
Yes, he
The
can.
trial
shut
court
it.
must give these instructions if there's any scintilla of evidence to support it. You know, whether it's
You can
reversible-
100% be fucking shot at from inside your house. Are you telling me the house is like a bulletproof bunker?
I mean, and there's one interpretation of the facts that you're giving, but there's another interpretation of the facts that facts in the record that show.
And remember, testimony is evidence.
Or provide at least a scintilla of evidence that the defendant that was being shot at. Whether the jury believes it or not, it'll be up to them. So, you know, I'm not going to get led into error I've done the research. I'm not going to get led into error because you have a separate interpretation of the facts. All right, let's move on. I'm going to put or use or attempted use or apparent attempted use or threatened use. We're going to remove all those brackets. All right, what about number 2, Ms. Larkin? And let me hear from you first.
Same thing, Judge. We'd ask for the ors.
Remove bracket.
Well, uh-oh, they're not happy, chat. They're not happy.
All right, now the next brackets is where we were before on justification. Let me hear from the defense.
Yeah, that
The
is
defendant
not
in
anywhere.
lawful possession or control of the premises is justified in, and then there are 1, 2, 3, 4 alternatives there.
I think the same thing's appropriate, the ors, and keep all of them.
This is just pouting. This is just pouting right now. She's just pouting. Oh, fuck it. You're gonna do whatever she wants anyway, because she's got nice perky tits, Judge. Yeah.
And then there's a bracket at the bottom. It says the force used may not be greater than reasonably necessary to prevent the attempted criminal trespass. So I'd say the attempted or actual criminal trespass.
Okay.
And then on the next page, let's see. And I would say committed or attempted.
And Your Honor, I don't think there's, I mean, maybe counsel can explain to me how I'm missing it. but
Tell me, first
there
of
was
all,
no
hold on a second,
trespass
just let me
in
tell
the
me
home.
show me where you're looking. What are you talking about?
I'm at the top of page 32. And there's the very first line. There are those brackets where it says committed, attempted.
And
we
Mr.
would-
Jetty, can I have your instructions again? Because my 32 is different. Sorry about that.
Do we just want to make a copy of the whole set, Judge?
Let me have the
for
rest
you?
of those. You can just look over
Yes,
this on me. Sure.
the state is
I'm sorry about
basically tipping their hand to what they're going to argue.
All right, I'm with you now.
Committed, we just want to say committed or attempted. And then the other bracket
That's not
where it says the
unreasonable.
defense ends when the attempted, I would say the attempted or actual criminal trespass ends.
Okay. Then the other instructions that follow were instructions that were included in, I don't remember if it was the states or the defense, but in anticipation of the possibility that there was a lesser included offense instruction added, I assume.
Sorry, we'd ask to take those out.
Negligent homicide, manslaughter.
We want them, Your Honor.
Are you requesting lesser included?
Yes, we are.
Fight it, fight it, fight it. Come on, don't let
What's
them.
the defense? But state can request lesser included.
We're not requesting lesser included.
All right, well, then we need another instruction. We need the general lesser included instruction. Well,
I think you already have it in here, Your Honor. If you
Oh,
look down to page 33,
They're not even going to argue about it.
is that what you're?
I think they're going to say their thing the whole time was he intentionally did it. You can't intentionally negligently kill someone. I mean, is the state acknowledging with manslaughter that the jury could see imperfect self-defense?
You're talking about?
Sounds like it.
and Mr. Jetty, last one he gave me was 30.
What we have here are a couple little bunny rabbits. And they're scared. They got the little bunny mustaches. And they're scared little bunny rabbits. They're scared. Oh no. Or if you're a Hannibal Lecter fan. Do you remember the Silence of the Lambs, Clarice? Do you remember it? Do you hear it?
Oh, I got it.
Sorry. Sorry about that.
It's pronounced 6-shooter.
There it is.
Are you on page 33, Judge?
I'm there, yeah.
I think we would just need to take out that second degree murder because it is a duplicate, but that is the lesser included
No, they got
from the Raji.
the defense wanted to go all or nothing. The state wants lesser included. Lesser includeds are in.
I think they should all go in order, Your Honor, starting with second degree murder, then the lesser, then the manslaughter description, then the lesser of the negligent homicide.
All right, so we'll take out that redundant second degree murder, right? And then we'll start with the crime of second degree murder includes the lesser offense of manslaughter and negligent homicide. Manslaughter, negligent homicide. All right. Then on to 34. What about the criminal trespass?
Your Honor, and I think that what we'd need to do, these are just the lesser included portions. It doesn't, oh no, they're in there. Never mind. No, I think we actually need to insert the manslaughter description right there where it says manslaughter on page 33. And then we would need to insert the negligent homicide instruction right under negligent homicide. Oh, that one's actually there, but the manslaughter one looks like it's missing here, unless I'm just missing it. And I think the only manslaughter that applies is the reckless, so I don't think we need to say it can be committed in two ways.
All right, I'll reorganize these. What about the criminal trespass in the first degree? I don't know where then.
And that's what we're requesting. And I think the definitions that go with it, we would just ask that we move those to be under the instruction on the
What's the trespass one?
It's part of the justification of defensive premises.
Oh, okay.
And so that just defines those terms. And we would ask that those terms, the criminal trespass and the definitions, be moved so that it makes sense for the
So
jury.
move to follow the justification.
Yes.
All right. Gotcha. Okay. We got some work to do.
Your Honor, would you like to hear my argument about the justification defense and the premises issue?
Go ahead.
There is a case on point, State versus Level, 97 Arizona 269, that talks about how the
We'll get to
trespassing
this.
has to be in the premises. The definition in 13407 says that premises means any real property and structure adapted for both human residence and lodging, whether occupied or not. So
You said real property and structure. Well, real property means land.
justification defense only applies when someone is getting into the home. There are no facts in this case that anyone's getting into the home. That's why this does not apply.
Where does that definition come from again?
13407 subsection C. And when we give the definition of criminal trespass in the first degree, it's misleading because the justification definition is limited to premises. And the criminal trespass in the first degree also has the fenced residential yard. And so that's misleading because the justification defense doesn't apply unless somebody's physically trying to get into the home. And so for that reason, Your Honor, I think that these instructions are completely misleading for the jury.
And Judge, the justification defense also applies to attempt. And if somebody's outside of your house with guns and shooting, it's certainly an attempt.
All right. We're going to take a recess. Let me get to work on these. We got a lot of work to do. And then we got to look at them and get them copied off. Hopefully we'll still be able to get to them this afternoon, but there were a lot more changes than I anticipated, but that happens. That's all right. All right. Anything else of a material nature that comes to mind?
No, Your Honor.
Judge, I'm just not sure if I indicated that and perhaps I did, and I apologize if I'm being duplicative, but we do oppose the third party one as well. If I made that argument already, I'm sorry.
That's all right. And you'll have another opportunity to make a formal record when we get to the final draft before you.
I just wanted you to know that before you got to work.
Got it. Thanks.
Just
We're going to get to
wanted
work. I don't know how long
you
this
to
will
know.
take, but we'll be working.
Okay, so that's it. And well, here's the problem, chattel. They are in the middle of closing arguments, and there's nothing here. There is nothing here. I tried looking real quick online, and the local affiliates kind of have potato cams going, so we're not going to go look for them. We do have some questions we can get to right now. I think they're kind of important ones. I'm here for $2 says, well, I'm going to come, homie. Yes. Senior SB Bergo says, based on the state's logic, doing a drive-by on someone's home is only a property crime, not attempted murder if someone's at home. Yes, that's basically, that's why I love it. I wish the state could be held to these arguments at future dates. Like, I wish something could happen there. Ow. I wish, if these judges, if I was a judge, I'd be like, you just said something different in another case, counselor. And that's James is what the fuck? My blood pressure is still so elevated from that pending legislation comment. I mean, my blood pressure is already elevated for these guys for multiple reasons. And then my blood pressure is naturally elevated because I'm fat. Matt says, is criminal trespass a justification for self-defense? I think, and the state's probably right about this, the self-defense argument would be a trespass into a domicile or a dwelling or some sort of building that you're in. Yes, the idea is somebody trespasses into your home. Like here, somebody trespasses into the hacienda or, Martinistan, whatever you wish to call it, the Martinistan Presidential Palace or the hacienda, whatever you wish to call it. If you're out here in my front yard, I can tell you get the fuck out, and I could use a little bit of force to escort you off the property. But you come in the house, I'm allowed to use a little more force to get you out. And I think there's a fair presumption argument. Coming into someone's home opens you up to an argument that you are there for unlawful means and your intentions are not pure. So we'll see. We'll see. Recovering addict has a live. He has it. Let me take a look. Because if it's there, I'll take a look and see what he's running. And where is he watching from? What channel is he watching? Do you guys know what feed he's running? Because I wish I could grab this. Because this does not look like an unlocalized feed. This looks like someone else's. Do you guys know what he's running from? Kelly R says, I know where it's at. Can you tell me then, please? Tell me. I gotta know. I gotta know. We also have time, so. Halfway. We're halfway there. Oh, did Log Crime come back to it? The George Kelly trial. Let me see. Oh, we got some actually we might have some options here, guys. Hold on. Hold up, chat. Hold. Closing arguments 1 or 2. Oh, we do have their arguments. Okay, we got them. We're going to go into it. We are going to go into it. Long crime or crime talk? Yeah, no. Oh, Kelly, I was already here on the their YouTube channel's already got it. Really? All right, we'll check their YouTube channel here. Hold on. Because this is where we've been watching the feed. It's from their YouTube channel. Maybe they were streaming this live. Yeah, their videos. Yeah, because here's I'll show you what I was looking at. When you click on this, for example, you can click on the Santa Cruz AZ Superior Court and you get caught up. Like, we're fully caught up. They don't have anything new. And this is where they put everything anyway. Deliberations just started. Yeah. Long crime. I didn't see them have anything, but we'll check again. But I found K-Gun. KGUN 9. The most appropriate to cover this. They started covering it. So here we go. Apparently this is it, chat. This is a different camera angle. I'm going to like this. No, Wombat Mommy. No. Chill out, everybody. Okay. They upload the current day's court at the end of the day. So you don't get to see what happened on the 17th until the end of the 17th because of bandwidth issues for the court. One of the local affiliates in Tucson filmed it. So we are going to go ahead and watch it because I found it on YouTube. One of the local news affiliates actually covered it and placed it so we can watch it. So here we go, chat. So here we go. George Allen Kelly trial. Closing arguments to the state, 1 of 2. So here we go.
This is the first time I've been able to address you directly. Once again, my name is Mike Jetty, and I want to just echo what Ms. Hunley said at the beginning. We appreciate your attentiveness during the entire trial. It's been 4 weeks. So we appreciate the time and devotion you have because it's a very important duty we have here. I'm going to start off by saying that I'm not going to go over every fact. I'm not. My job here is to take the wheat from the chaff here and focus in on the important things in this case. Our goal here is to simplify. So if there's a fact that I didn't cover, don't read into that. You're the deciders of the facts to apply to the law the judge just read. Okay? State v. Kelly, this occurred on January 30th of 2023. Oh, I'm sorry, was this, the whole thing was not, I'm sorry, Lydia, that's my bad. Like I said, my job here is not to go over every fact in this case. State v. Kelly, it's an event that occurred on January 30th in 2023. Gabriel and Daniel were in the U.S. seeking the American dream. Yes, both were undocumented migrants. Both were escaping extreme poverty. The defendant sees Gabriel and Daniel running back to Mexico. Not just running back to Mexico, 115 yards from his property, beyond 2 fence lines. And they're running because earlier they found Border Patrol. The group scattered and the 2 took off. The defendant sees them beyond the 2 fence lines, 115 yards away, picks up his AK-47 that he keeps by the patio door, steps outside of that patio, on that patio door, or the patio area, and without verbal warning, without a shout, without any indication to both Gabriel and Daniel, points that weapon at these 2 men and shoots over and over and over again, 9 times. Gabriel was judged that day and sentenced to death by the defendant. Picture of Gabriel.
This is. I'd almost object and say, Your Honor, this is really fucking cringe. That was cringe as fuck. Really? Come on, man. That's something like a law student would argue.
And that's a picture of the AK-47, the weapon used.
God, that picture's compressed because it looks like he's running a short-barreled AK.
That weapon.
Oh, he used PMags. Based boomer with the PMags.
Weapon can fire 30 rounds in 6 seconds.
A lot faster in 6 seconds, homie.
You were out there. We had a jury review. I forget which week it is now. I think it was last week. And that's a view from the patio and the gravel. This is 14 months ago. So obviously there's new growth out there. We're all out there. You see us, an individual out there. This is the site view for the patio and gravel. You saw this picture earlier in opening. And that is Detective Barba out in the distance. Question you have to ask, is that a threat? Is that a threat to you? The answer is no, it's not a threat to the defendant. That's a picture of Gabriel in the high grass. Lights in the background of the Kelly's home. Position of the body, orientation of the body, the injury matches up directly with the defendant's home. That's the injury wound caused by the projectile, which matches up with the defendant's home.
No, it doesn't. No, it doesn't. Not even fucking close.
That's a picture rolled over. Gabriel rolled over, hand clenching his chest. I've been shot. Falls forward.
Tough break, homie. Next time, get a passport.
And dies. That injury breaks 3 ribs, perforates the right lung, 3 lobes of the right lung, and severs the aorta.
You guys want to rewind real quick?
Perforate,
Yeah, here, we can see his
rolled
picture.
over.
There he is. Looks like every cartel dead person murdered by the cartel.
That's a picture. Perforates the right lung, 3 lobes of the right lung, and severs the aorta. You're not moving after severing the aorta.
Yes,
You're
you
done.
can.
Life is over.
I'd object. That is a fact, not an evidence.
Let's picture a drone. We're gonna walk through it. So the cones, that's estimated by Detective Bunting where the shooter was standing. We're gonna go past one fence line. We're gonna pass a second fence line. This is a distance here. 115 yards. We're going to see some red cones here where the victim's body was located. And we all stood out there on that site. Camera's going to pivot. We heard from GPS that they took the drone footage and put it on a mapping of some sort, and it gives us this GPS mapping. The blue line on the left-hand side, that's the north-south directional line. The red one, east and west. And that green line is the patio to the victim's body. And that's the orientation of the victim's body. We'll say it again, matches perfectly from the patio to the victim, the orientation of the body. The defendant shot 9 times. He's been charged, secondary murder,
50 cents.
and aggravated assault with a deadly weapon. Secondary murder, you heard from Ms. Hunley in the opening, is a unified offense. There's 3 ways to prove it. You don't have to agree on all 3 ways, but you have to agree on secondary murder. First way, Kelly intentionally caused Gabriel's death. You walk out on a patio and point a gun at someone and shoot 9 times. That's intent. Kelly caused Gabriel's death by conduct Kelly knew would cause the death or serious physical injury. An AK-47 is a serious weapon. It's not no play toy. When you fire it 9 times at a human being, it's a serious activity. Third, under circumstances manifesting extreme indifference to human life, Kelly recklessly engaged in conduct that created a grave risk of death and thereby caused Gabriel's death.
Yes,
the risk
found
must
19
be such
days.
that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. 2 men walking southbound, no danger to you, and you don't even give a warning? Hey, get off my property. Get off my property. Or just sit back and let them continue on. Facts of this case. Gabriel and Daniel were shot at. Gabriel is dead, killed by a high-powered weapon. An AK-47 is such a weapon.
Only high-powered, successful people use high-powered weapons, chat. And they use them at a high-powered earners summit. Only for the alphas do you use high-powered weapons. Us betas merely are resorted to low-powered weapons.
Kelly wound is to the right side back. Exit wound, the chest. Consistent with the direction of the defendant's home. Defendant's words on his dispatch or BP to dispatch to officers and during Detective Ianza's interview, inconsistent Every single time the story changed. Every single time the story changed. Daniel's words, consistent. Heard an AK-47, horse saved his life, heading southbound. I just want to repeat real quick since we're on Daniel. Daniel's the only one in this courtroom, on this hill, and likely in the city of Nogales, who's ever been shot at with an AK-47 9 times and be next to a friend who just died. So maybe during his testimony, distance and time is a little skewed. Just maybe. If he knows it's an AK-47, he knows it's a red horse who saved him, and he's heading southbound. Defendant steps out, no verbal warning. Defendant shot his AK-47 9 times. There's shell casings found with the ejection pattern that matches what DPS forensic scientist Burnell is consistent with the ejection patterns and position orientation of the body. Once again, matches up with only one known shooter. You've heard instruction, there's also a lesser included. So if you do not find beyond a reasonable doubt the defendant caused second-degree murder, you can consider manslaughter. And manslaughter, as a judge read, and you'll have jury instructions, and we'll spend too much time on this, it requires proof the defendant caused the death of another person, and the defendant was aware of and showed a conscious disregard of a substantial and unjustifiable risk of death. Stepping on a patio with an AK-47, shooting at 2 armed men walking southbound, no danger to you. And if you don't find second-degree murder, and you don't find manslaughter, you can consider negligent homicide. Negligent homicide requires proof of the defendant caused the death of another person. The defendant failed to recognize a substantial and unjustifiable risk of causing the death of another person. Aggravated assault, second charge. Aggravated assault with a deadly weapon.
Yeah, didn't he just admit
The
they were?
defendant
I kind of
committed
get
an
that
assault
feeling.
against Daniel. And the defendant used a deadly weapon, an AK-47. Assault requires the defendant intentionally puts Daniel in a reasonable apprehension of imminent physical injury. Steps outside with an AK-47 and shoots that gun.
Mm-hmm. Yep.
And that's the horse. According to Daniel, saved his life. He recognized that horse. He identified that horse. That's the defendant's horse. And that horse was between him and the Kelly's residence. Defendant's words. I'm not admitting to anything I've done, but all those things tend to add up. And they do. Removing the wheat from the shaft here.
The chaff. Oh my God.
Agent Marcel, first witness for the state. 2:30 phone call. I'm going to summarize these for you. First phone call. I'm being shot at. I'm shooting back. There are 5 people, all packs, with packs running southbound. I'm being shot at and I'm shooting back. 5 individuals in this story. That's at 2:30 in the afternoon. 6 minutes later, defendant changes that story. I had an altercation with someone. I heard a gunshot in his direction, in my direction. Inspected his horse while they spoke. I'm gonna argue he inspected his horse because he shot his gun 9 times. He wanted to make sure he didn't shoot his own horse. We were too far to tell if any of them had firearms.
Okay.
And that's probably the most truthful thing he says here. Because you were out there, 115 yards is pretty dang far away to see a firearm on an individual.
Not really.
2:40, 10 minutes after that first phone call. And what's happening in the background with 2:30 is BP is now communicating to SO dispatch. And SO dispatch is doing a code 3 alert, and lights and sirens going off, and all SO people are responding to scene, because to them, they think it's an active shooter. We want law enforcement to believe, when we call them, we want them to believe the story. They're not here to second guess it. So lights and sirens are going. And 10 minutes after that phone call, respond, active shooter response. You heard testimony. Goal is number 1, preservation of life. BP locates a defendant near his barn. You heard Agent Heredia on the stand. He appeared calm. 10 minutes after being shots fired, I'm shooting back, the defendant is calm. He's calm. He's carrying an AK-47, walking with his 2 labs. No one located on the property on a security sweep. No one. 3 p.m., defendant says people were possibly carrying rifles. Possibly now. We went from, I'm in a shootout, to too far to tell, and now maybe not, maybe so. They were 100 to 150 yards away from his property.
Turns out just a
Castaneda told the defendant that if anything like this happened again, don't do anything, call 911, stay in your house. And his response, understood it. He said, I want to do what he had to do to protect his property. He was conscious of the consequences. He would take responsibility for his actions. Talking to BP and SO, the defendant never admits that he shot his AK-47. We've got Border Patrol and agents on scene for an active shooter situation, and you failed to tell them that you shot your own weapon? Never told law enforcement that anyone pointed a gun at him. Didn't tell anyone. This just happened. This literally just happened. And you're not telling a single soul that people are shooting at you? Never told law enforcement he was in fear of his life. 423, he's calling. I think this is a thank you call for Agent Marcel to get a quick response to him. In this call, he says, now, instead of 5 folks, we have 10 to 15, all loaded with AR-style rifles. We're getting exaggerated statement here now. 523, this is the second wave of phone calls. That was the first wave, active shooter call, and now we got the calls and dispatch recording related to Gabriel's body. Jeremy, this is Alan Kelly. You need to call me immediately. This is serious. Call me immediately. I can't say more on the phone. Why can't you say more on the phone? Why can't you say more on the phone?
Who knows? You can't.
526, he sends that text message.
You tell me why he can't say more over the phone. That's your job. Why can't he say more over the phone? Maybe he's like, I'm going to have to go dust some motherfuckers. I don't know.
535, here comes the 4th phone call. This is worse than you can imagine. This is bad.
Yeah, he's never been shot at before.
Marcel told Kelly, call 911 and talk to SO. He never does. He never calls the SO. The SO calls him. Because Marcel does what a Border Patrol agent is supposed to do. If there's an immediate emergency, he routes a call to the local law enforcement, which is the SO. And the SO then, without him calling, calls him to find out what's going on. What's so serious and why immediate response again? You know how shots were fired earlier? Something was possibly struck. Just say, there's a body on my property. Just say it. When Marcel asked for additional details, Kelly said, I can't tell you over the phone. Ask Marcel if this was being reported. It's a noteworthy question right there. This is that dispatch call. Got my microphone. Let's see if we play it.
Hello?
Hi, sir. I'm calling from the Sargent County Sheriff's Office.
Yes.
Hi. I'm just calling because we received the report from Border Patrol.
Yeah.
So I was just calling to get more information. So what happened?
You're gonna have to send, an officer out here.
Okay, what's going on?
I can't,
I'm sorry?
it's very serious, ma'am, and I'm not gonna talk over the telephone.
Okay, I understand it's serious, but I need more context in order to send a deputy.
Okay, fine. It's gonna be,
Go ahead, you can talk to me. What's going on?
yeah, I know I can talk to you, but you're responsible for what I say, and I'm responsible for what I say.
Can you give me a little context of what happened? What's going on?
Face Boomer, he's trying.
You told them
I'm not sure.
what did you shoot at?
I didn't shoot at I haven't said I shot at anything.
Okay, well, that's what Border Patrol told us, so that's why I'm just asking you.
Yeah, y'all guys, the Nogales Sheriff Department had 4 or 5 guys out here this afternoon investigating a Border Patrol drug running incident. And I don't know if I can't remember the officer's name. There was 2 gentlemen and 2 young ladies. And they third. Do you know who I'm talking about? They came out to 100 Willow Cross Circle.
You mean for my deputies, correct?
Yeah, they were Nogales.
Yes, aware of what happened earlier.
You're aware? Okay, then they're aware of what happened, and I don't want to get you in trouble, and I don't want to get me in trouble, but I don't want to break the law or anything like that. So what I'm telling you is that we need a sheriff deputy out here, 100 Willow Cross Circle, immediately, and that's all I can say, ma'am.
Okay, is anyone hurt? I need to know because if someone's hurt, I need to send an ambulance too.
There's no.
Okay, do you feel more comfortable talking to a deputy over the phone?
Well, in other words, okay, you know the thing. You have the right to remain silent, and anything you can.
I understand.
You say can, it will be held against you. And of course, I'm not admitting to anything I've done, but all those things tend to add up, and I don't know what happened. I just know what I just saw about 15 minutes ago, and it's something that an ambulance cannot help. EMTs cannot help. There's nothing out here that can be aided by EMT or emergency services.
Okay, I understand you don't want to give me a lot of details, but what you are requesting an officer from me, so I needed to know for their own safety and your safety a little bit of what's happening, what's going on.
Okay, I'll put it like this. Last spring out here, there was a pickup found on East Sagebrush with a dead lady in it. I don't know if you knew of that or not.
Yes, sir. I'm aware of what happened.
Okay, it's a situation similar to that. How's that?
Okay.
You follow? You understand what I'm saying?
I
It's a
understand what you're
situation exactly like that.
Okay.
And so that's going to require the sheriff to come out here.
Okay, can you tell me a description of, does it
No,
show the vehicle?
I don't have a description. There's not a vehicle.
Okay,
The only thing that I was referring to in conjunction with that accident was the body.
okay,
You got it?
okay, all right. Okay, can I have your name?
Yes, George Kelly.
George Kelly. Okay, George, would you, if my deputy goes over there, would you take him to whatever it is
Yes,
that you found?
Yes, I have it marked. I have a flashlight on over it, because it's gonna be dark when he gets here probably, but I'll take it to him.
And you are sure an EMT cannot help?
I am positive. I have a medical background. An EMT cannot help.
Okay. Do you know whoever it is that you saw?
No, I do not know. I didn't say it was anybody. I just said it was a body.
Okay. All right. Okay. All right.
I'm not trying to be smart, ma'am. I'm just
I
trying to.
understand. You're trying to be careful, and I get that. However, I hope you understand that on my end, I have to take care of my deputies too. So I
Yes, I
need a little
understand.
bit more context as to why you needed a deputy to head out there.
Now you know that there is a body here.
Okay. All right. Does it look somewhat?
And it's not alive. So you asked, did you need EMT? I said no.
Okay.
I'm sure a coroner will be involved sooner or later.
I understand. George, can you tell me something? Is it discolored from somewhere?
Is it discolored?
Yes.
What does that mean?
Has it been there for a while? Can you tell?
From what? In that I only approached the body to make sure that the animal is not a vegetable or mineral. The animal wasn't alive and it was not alive.
Okay.
There were no signs. There was no signs of blood. There was just an animal laying face down.
An animal?
An animal, and you know what an animal is. It's not a vegetable or a mineral.
Okay.
It's a body, and you know what I'm talking
I
about.
understand what you're talking about, George.
Yeah.
Okay. I'm gonna send the deputy then over to your house so you can lead them over to wherever you found what it is.
Okay.
Okay.
And now,
We'll
maybe
get to this in a
one of the
minute. Okay?
deputies are out here. They know how to get here because it's 100 Willow Cross Circle, and it's kind of hard to find. It's a ramp right on the border.
So I
So
have one of my deputies that responded earlier going over your way.
that's good. You do that. They know how to get here, and I'll have to get over.
Okay. Sounds good, George. Thank you. Thank you for
I appreciate your help and your patience, and I'm sorry if
I said.
Okay,
Okay.
bye.
Thank you.
That's a phone call SO had to make to the defendant. And it says it's very serious. Recap, very serious. Can't tell, am I going to talk over the telephone? I don't want to get me in trouble. I'm not admitting to anything I've done, but all those things tend to add up. Detective Lopez gets on scene. That's Exhibit 38. I'm not going to play that for you, but that's admitted into evidence. That's that recording. The Deputy Lopez recorded. He says in that, quote, defendant, I have no idea, I have no idea, I have no idea. You know, if you were me, you got no idea. You know what I'm saying? You literally shot your gun 9 times, and you've got no idea what possibly could have happened.
Police make
Sergeant
that
Rodriguez
argument
gets
all
on
the time.
scene, 6:15. Sergeant Rodriguez is the one that pronounces Gabriel dead. That's not the time of death. That's the pronouncement of death by law enforcement. No pulse, extremities are cold, but his torso was still a little warm. Importantly, there's no drag marks, blood trails, or foot traffic evidence anywhere. It appeared as though Gabriel fell where he was shot. At this point, Sergeant Rodriguez does not know Dr. Tim's autopsy results. A severed aorta. That's a drop shot. You're going down. The entry wound lined up with the east patio of the Kelly residence. Again, entry wound and orientation. Lines up. And then the defendant has an interview with Detective Ainza. In that question, he says, question, did you shoot? I have no reason to believe I shot this person. Ainza, what does that mean? Defendant, it means I have no reason to believe I shot him. That's simple. Question, did you shoot? No response. No response. Detective Ainza at this stage has already talked to Border Patrol. He's already talked to dispatch. He's already talked to SO. So Detective Ainza has information. And during an interview, he's not going to disclose the information. He wants the defendant to talk to him. And it does not say he shot his weapon. And until 30 minutes into this interview, about 15-minute interview, he finally does. And this is the interaction. Look at me. I can see it in your eyes. Defendant, I haven't said I didn't shoot. Did you shoot? No response. Towards these gentlemen. No, I did not shoot at those gentlemen. Did you shoot? All Detective Ainza is trying to figure out is, did you shoot? And finally he says yes. Then he says, I shot over their heads. Shot over their heads. He shoots in their direction, says it this time. Ainza asks if it's 100, 150 yards away. He affirms that. And he says they were armed. Remember an earlier statement, too far to tell? You were out there. And I shot 100 yards over their heads. I didn't shoot at them, I shot over their heads. Ainza, you shot towards the direction of their heads? Yes. Does not admit he shot his AK-47 until 30 minutes into that interview. You saw pictures of the shell casings, you're out unseen. Right next to, if I'm on the patio, they're right to my right. 8 shell casings found. And those are the 9 total. 1 in blue found by the ATF K9. K9 alerted the evening of, that's around 12:30 in the morning. And the next day when it's light out, they found the other 8 shell casings in yellow. And that ejection pattern, as we're going to see in a second here, is consistent with the ejection pattern of DPS forensic scientist Brunel's review of that weapon shooting the exact same rounds. We get to the AK-47. Where was this gun? Where was this gun that he keeps by the patio door? It was hanging up on a coat rack on a bedroom door behind a sweatshirt. And the only reason it was found was Sergeant Flores opens the door stops its momentum, but the gun continued and bumped the back of the door. He looks behind the door and sees this weapon. What's not true in this case? What's not? There is no evidence of a mysterious shot. None. The only person in this courtroom who's ever said anything about a mysterious shot is the defendant. His wife doesn't even say she heard a shot. And you heard when Ms. Hunley had Ms. Kelly on the stand, you wonder why we asked the question, what were you watching? I was watching a news show. What was the volume? It was on 20 out of a range of 100. You're in your living room. Your husband's in the kitchen. He hears a gunshot and you don't. And you're watching and listening to news at a medium volume. That's a mysterious, magical gunshot in this case. No evidence that it exists. None. The other one is the boogeyman. We've got a lot of armed men on the property. We went from 5 to 10 to 15, all carrying packs, all with rifles, walking this property. They changed the number. They changed the distance.
No, what? Hold on.
They're creating a...
When was there 25 people there? I've only heard 5. This is bullshit. This is bullshit. What's on the pizza? None of your business. pizza.
A fear here of the boogeyman being there. There's no evidence. None. You have two
You're going to tell people in Arizona that border violence is a boogeyman? That's not a good idea.
migrants come to the U.S., heading back to Mexico, who get shot at. Defendant under fire. No evidence whatsoever. They did a search with a metal detector from the house to the victim, no other shell casings, and from the victim out, no round or other shell casings. None. No damage to the house. You're being shot at. If you're in your house and you're being shot at, where's the damage to the house? No evidence of drug packs or drugs. No evidence of robbery or theft. No evidence of struggling or dragging. None. Someone else must have shot the victim because the victim stumbled over. This is a severed aorta. You don't stumble around. You heard Dr. Tim. You may take one or two steps and may utter a gasping phrase or two, and you're done. During voir dire, I think it was mentioned by
What happened to the
counsel
American
that
dream,
this is
exactly?
a shoddy, I'm paraphrasing, this is a shoddy investigation. Here's everyone involved in this investigation. Local law enforcement, we've got Border Patrol agents, we've got DPS, we've got outside experts, medical examiner, we've got a guy from Washington, Mr. Wyatt, we've got Mr. Telsell from the East Coast, we have the FBI. This is a thorough investigation. This is Agent Douglas, who you heard on the stand testify about downloads from the defendant's cell phone. You saw that? AK getting a lot of work. 33 dealt with this week. AK hot. AK hot again. It's either fight or run until to run. There's BP cameras out there. Anything like this? Expert witness you saw, I mentioned him earlier, DPS forensic scientist Brudenell, talked about the functionality of that AK-47. It works, it's operable. Talked about the ejection pattern, which is consistent with his testing with the results on the scene. Rounds coming out to the right. Doesn't matter if you're right-handed or left-handed. No matter, the projectiles are coming out of the right-hand side of the gun. The injury is consistent with a long-range shot. Why do we know that? Well, we have two things we got going on here. We have GSR, we have that cloud from a gun. When you shoot a gun, there's a cloud of particulars that come out. And you heard testimony that usually within 20 feet, some of that cloud dust is going to come on to the person. Well, there is no GSR in this case, which means only other reason is you're further than 20 feet from the victim. That's what it means. This ain't no close range shot, holding the backpack and doing a gangster style shot. That's not what's going on here. Because there would be a cloud. There'd be gun residue all over that person, all over him. There's none. You heard the witnesses. They damped the clothes all around and submitted to Ms. Tossell. You heard testimony. No GSR found, which means further than 20 feet. I think it's easy to say that 115 yards is further than 20 feet. We also heard from DNA and fingerprint analysts from DPS. The reason we did is we're doing a thorough investigation here. We're demonstrating to you, you deserve to know that the government is doing a thorough investigation. That's our job. And there is none. Not surprising. There's only two people involved in this case. Or three, count Daniel. Rick Wyatt, expert from Washington, talk about ballistics, talk about the wound, the bullet used is consistent with the wound, shooting reconstruction, and he talks about the bullet being a yaw. I'd call it a wobble. It hit something on his way. It hit something on his path. So instead of being like a nice little spiral, it's like a duck, like someone throwing a duck football. There's a little spiral off. When it hits that body, that's why the entry wound's a little off. And you saw the scene, mesquite trees all around, can hit branch anytime. It was Rick Wyatt who asked SO to go cut that branch. Just to double check. There's no evidence on the branch. It's an indication to you all why the bullet is in y'all. It hit something before it hit. And that's why there's no bullet wipe. Which means when the bullet's carrying some of that particulates on its way, on its journey, and when it enters the body, it's going to leave what we call a bullet wipe.
This is
There
bullshit.
is no bullet
This
wipe in
is
this
bullshit
case.
science here,
Because
guys.
that bullet is in y'all because it hit something before hitting the victim. There's no mystery to that. Ms. Telsell talked about no GSR found. You heard from Dr. Tim, cause and manner of death, homicide, bullet wound, injuries consistent with an AK type weapon, from collapse to possible step or two, there is no walking with that injury. There is no walking, stumbling around. There is not. Then I just want to talk about the skeleton because that was demonstrative used in this case where defense counsel put the rod, the trajectory rod through the skeleton and said that must have been the trajectory of that round. That's kind of like a gangster style shooting where you're trying to take the backpack and you're coming up from underneath and you're shooting. You heard Dr. Tim talk about this and you heard Daniel. Possible reason number one, when someone shoots a weapon at you, what's your reaction? To duck. And the moment you duck, you line that body up. You line that body up. The second, you heard Dr. Tim say, once it hits that rib cage.
What if it's the first hit? It makes no sense then, right? If it's the first hit, if George Kelly stood up with that AK and he goes, boop. Excuse me. And what if George Kelly gets that first hit? He gets a first round hit. He wouldn't have ducked. So how do you explain the bullets? You cannot. This is, once again, gun people, non-gun people trying to talk about gun shit does not work.
It gets deflected inside the body. There's two reasons why that is the way it is. Not because there's a robbery, not because there's 5 guys out there trying to take quote-unquote drugs off the victim. Entry wound, like I said, in yaw, exit wound coming out of the body. It's interesting. Had my gun, shot my gun. He says at 2:30 Border Patrol. Doesn't tell Marcel ever again. He had a couple conversations with Marcel after that. Does not tell him. Does not tell BP Heredia on scene. Had my gun, shot my gun. Does not say that. Does not say to Deputy Monreal on scene. Does not say had my gun, shot my gun. Does not say it. Castaneda on scene. Does not say had my gun, shot my gun. These are officers who are responding to a code 3. This is lights and sirens. This is an emergency. Does not tell Deputy Lopez, had my gun, shot my gun in this event. Does not tell Sergeant Rodriguez, who's the one who pronounced the victim dead. I had my gun and shot my gun. Does not say anything. Nothing. And you wonder why no one's looking for shell casings around the property? Because no one knows, quote, he shot his gun. No one knows that. Because the only person who's talking to Border Patrol is going to be Detective Aiza, and he's here at the station. The defense never says, had my gun, shot my gun. Never. And Aiza, after 30 minutes, he finally admits, had my gun, shot my gun. Dispatch Supervisor, Ms. Huerta, Defense Exhibit JJJ. At 3:05, Border Patrol contacted Wanda Kelly. And Wanda Kelly, according to dispatch, says, my husband's giving chase. Okay. Husband's giving chase. And to their story, there's 5 armed gunmen with AR-style weapons on my property. There's a shootout, and you're going to take your weapon and go chase them. You heard it on the dispatch log. It's Exhibit JJJ. You guys can pull it up. Canines and the defendant and the canines are on scene first. It says, there's a quote, canines disturbing the scene. Canines are at the body. 642, Rodriguez is trying to confirm with Border Patrol the subject struck something. There's no jumping to conclusions. None whatsoever. He's asking for confirmation and he gets confirmation. Deputy Castaneda, this is Juan's statement when he's on scene. 5 individuals, some carrying rifles. Defendant grabs his rifle he keeps by the door, not hanging in the bedroom door under a sweatshirt, keeps it by the door. Went outside, heard shots outside. Does not say the shots she heard were the defendant's shots. And then he takes off and leaves her to go chase the marauders. Defendant states that they were running south in pursuit. Importantly, Castaneda on scene, no rifles, no backpacks, no signs of a large group of 5 people passing through. None. Agent Marcel, it's important. Agent Marcel told you there's no rip crews in the past 10 years. No AR-15 rifles ever found in the past 10 years. And if this is being reported, that quote, he said it meant to him, he thought it meant, is this being brushed under the rug? Undocumented migrants, you heard testimony. Migrants, not drug dealers, not gun carrying, toting drug guys, but undocumented migrants coming here to the United States for a better life make up 98% of all apprehensions. 98%. They all wear camo because migrants also don't want to be detected. And they all carry backpacks with food and water. There's no mystery here. 0, because you have a backpack. None. Migrants use radios for pickups. When they come into the country, they're going to get picked up in a car to get transported. Yes, this is all arranged. We're not dummies here. We know how this works. But having a radio does not mean you're a drug dealer. Having a radio means you're communicating with someone so you can get picked up later on the side of the road. So you can be traveled to Tucson or Phoenix or wherever you're going.
Okay, yeah, that's
The
it.
defendant was reluctant to have the SO respond. And cartels, when they get involved, they make things messy. There's no single shot with a cartel. None. Daniel, the victim, an eyewitness. From Honduras, extreme poverty.
Counsel,
Yes,
we're about due for, we think the jury's been in here since about 9 o'clock, so it's been about an hour and a half. I'm sorry to interrupt you, but we have to take a recess. So we'll take a 20-minute recess. We'll be back here in about 10 to 11. We'll stand recess until 10:50, 10 to 11.
Okay. Okay, so that is part 1 of 2. Then there's part 2 of 2. Here we go.
Please be seated. The record is show the presence of all the jurors, counsel, and the defendant. And as soon as you're ready, Mr. Jenny, you can continue with your closing.
Thank you, Your Honor. We left off with speaking about Daniel, the second victim and the eyewitness. What happened? What Daniel is not part of a drug organization. He's not. He doesn't work for the cartel. He does not. 6th grade education.
His friend was a drug
Only
dealer and
been
worked for the
about a year.
cartels.
There's a picture of him in testimony. I'm talking about consistent statements. AK-47 shot, red horse. He also nailed it on how the victim died, clutching his chest, arm up. And that is the picture we see of Gabriel. They crossed, no weapons or drugs. No one in the group had weapons or drugs. No one. Returned to Mexico, and the shots were fired. These are 2 unarmed migrants heading back to Mexico. Shots coming from the defense property. It tells you shots are coming from the right-hand side, and the horse is saving his life. Heard 8 to 10 shots. There were 9 shell casings found. Consistency. And he is scared. Being shot at with an AK-47 is serious. Seeing your friend die in front of you is serious. Grabbed his chest and said, "I'm hit." Agent Heredia, first on scene at 2:40. No people, no tracks, looking for the defendant. Remember, this was an active shooter response. Saw no rifles, no backpacks, no drugs. And the defendant was calm. Kelly said, we met up with him. He said that 5 to 7 people were carrying bundles. He went from 5 people to 10 to 15, back down to 5 to 7. It never mentions, with Agent Heredia, never mentions he said he was shot at. Never mentions he was shot at. Never mentions he saw a weapon. Never mentions a weapon was pointed at him. He's calm. Never mentions he even fired that weapon. It's 10 minutes after this shootout event. Unreal? Miss Kelly saw 5 armed men. Kelly went after them, heard 4 shots. Those are the 4 shots, 4 of the 9 shots by the defendant. The defendant said, "This baby is always by the door." That's an AK-47, which is behind the bedroom door, hanging up on a coat rack behind a sweatshirt. That's the same AK-47 that he always keeps by the door. He says they were possibly carrying rifles. Officer asked, did the armed men shoot at him? Didn't know what direction they shot. Justification instructions. There's a litany of those in your packet. You got one for use of physical force, one for self-defense, one for use of deadly physical force, defense of a third person, and defense of premises. That's your homework. I'm going to tell you, cheat sheet is always a reasonable person standard. So when you see 2 unarmed migrants walking southbound beyond 2 fence lines, and you take your AK-47, you walk out and don't say a word, point it at them, and you shoot, would that be what a reasonable person would do in that situation? The answer has to be no. The answer has to be no. No evidence of any armed gunmen. No one found on BP footage. No foot traffic. No other shell casings. And they used metal, I think they used up to 3 metal detectors on 2 different days. No other shell casings found. No one heard the mysterious shot, the made-up shot the defendant now claims started this entire event. He has to give you something. They got to give you something to justify why he shoots 9 times at a migrant. He has to give you something. It gives you this, quote, mysterious shot that even his wife does not hear. No evidence of drugs, guns, a struggle, robbery, anything. And when the cartel gets involved, they leave things messy. They also don't leave evidence. No evidence of any rip crew in the area. You heard Agent Marcel on the stand. Not in the past 10 years. Not in the past 10 years. No justification for stepping on your patio with an AK-47, not giving a warning, and shooting 9 times at 2 men who are southbound away from your property. No justification at all. Reasonable doubt? You got a jury instruction on that? What I want to talk about is your common sense and experience. We're in this is a magical area we're in. This is what democracy is about, sitting in a jury, listening to a case, and determining the guilt and innocence of an individual. This is what our democracy is about. But you still use your common sense you use in everyday life. You still use it. I'm going to give you an analogy. I think the judge used the analogy for direct and circumstantial evidence with the rain outside. He told you if you didn't see it, you have no direct evidence of it. But you go outside, there's circumstantial evidence of rain. I want to use the same thing for reasonable doubt. We're sitting inside this courtroom, and you go outside, the facade's all wet, the pavement's all wet, people are carrying umbrellas. You were here all day long for the past 4 weeks, but you're here all day long. You don't hear it rain, you don't see it rain, you don't smell it rain, you don't smell anything. You don't smell the bushes and the wonderful odor, you don't smell any of that. However, is it beyond a reasonable doubt it rained? Yes. Is it possible that a truck came by, a fire truck came by and sprayed the facade and the ground? Yeah, possible. That's a ridiculous doubt. Use that same standard here. The same standard. There's no bandits out there threatening the defendant? None. Facts again, Gabriel and Daniel were shot at. Gabriel is dead. Killed by a high-powered weapon, an AK-47. Entry wound, right side, exit wound, chest, lines up perfectly with the defendant's property. We're calling the wheat from the chaff here. Defendant's words, inconsistent. Defendant's words actually were consistent with some of the physical evidence. Shot 9 times. Eventually he says he shot 9 times. And now we have shell casings. Consistent there. And Daniel's words, always consistent with the physical evidence. Steps out, no verbal warning. Defendant shot his AK-47 9 times. Shell casings found. Ejection pattern consistent with what Brunel did on a test of that same weapon with the same rounds. Position and orientation of the body lines up with the defendant's home. I'm going to ask you, we'll come back second time and we find him guilty of second-degree murder. But you also can decide if you're not satisfied with second-degree murder, you can consider manslaughter. If not satisfied with either second-degree murder or manslaughter, you can consider negligent homicide. And finds him guilty for aggravated assault with a deadly weapon against Daniel. We'll leave you with this. Detective Ienza says in the interview, the moral of the story is you shot and someone is dead. And his answer is yes. That's all I have here.
Wait, what? Hold on.
That's all I have here.
Wow, these K-gun guys are just like, that done. That's like relentlessly brutal. They gotta chill out. They gotta chill out here. That's way too fucking fast.
I just want to start off by telling you this about this case. And it's first and
Oh my God, whoever filmed this, do you get paid by saving data on your recording device? Come on, give us 20, 30 seconds before and after. Come on now.
your jury instructions, when you go back to review them, they're going to tell you don't guess. You're not supposed to make guesses about what happened in this case, and you're not even supposed to solve the mystery or discover all of the facts that were left out of this case. Don't guess. We have this very high standard in criminal cases. The standard here is proof beyond a reasonable doubt. Not is this questionable, not is this suspicious, not even is this likely, not even is this really darned likely. The standard is proof beyond a reasonable doubt. And I'm going to come back to that standard, but we have that standard for a reason. This is the most serious type of courtroom that we ever get in any kind of case in this country, is a criminal case. And for the most serious type of courtroom, we have the most serious standard of proof. And it's your job as jurors to hold the government to that standard of proof. We don't guess when we're dealing with criminal law. We don't guess when we're dealing with criminal charges. So please don't guess. I'm going to ask you to assess the facts of this case. We have two competing versions of events in this case. We have the state's idea, and the state says that Mr. Kelly walks out of his house one day with no provocation whatsoever. He takes aim at a great distance at people who are unarmed on his property, and he fires shots intending to hit those people. That's their version of events. Mr. Kelly and his wife tell something very, very different. And I'm going to talk about what they say happened here, but I want you to ask yourselves while I'm going through that, is what Mr. Kelly and his wife says consistent with the facts, the known facts of this case, the known evidence that has been presented to you? Not, is this consistent with somebody's subjective interpretation of somebody else's words? Those aren't facts. Those are guesses. I want to ask you if what Mr. Kelly said happened is consistent with the facts. And it is. The evidence has showed that Mr. Kelly comes from Montana with his wife, and they eventually settle here, and they begin ranching. The evidence showed you in this case that they had a long time on this ranch before anything, happened. They've been here for decades. They are locals at this point. We heard from Wanda about the increased activity that took place on their property that we talked about in the opening statement. Wanda testified to that. You heard from Mr. Kelly about different instances where he was shot at. When he was interviewed by Detective Einza, he described those instances. We heard from Gary Wisdom, one of Mr. Kelly's neighbors who's in that same area, the same thing. When he originally started ranching there, he saw small family groups and didn't feel any danger. Gary Wisdom later says, eventually I started seeing bigger groups of men carrying weapons. And he called Border Patrol to report that at times. Border Patrol came out. He has no idea if they ever caught them or not. We heard from Border Patrol that this is a high trafficked area. There's a lot that comes through here. It's just north of that area where the wall ends. There are people who come through. There are drugs. There are vehicles. We heard from Border Patrol that it's impossible to distinguish nowadays really who's carrying drugs and who are just groups of migrants, because the drugs have gotten smaller as time has gone on. We have heard from Border Patrol that there are things that exist called rip crews. There are bandits. There are people who will rob migrant groups, who will kidnap migrants, who will steal drugs, and who will get into violent altercations with other people who are engaged in criminal activity in this area. That's not Mr. Kelly's imagination. That's what you heard from Border Patrol, who are out there every day on the ground dealing with what goes on out there. Border Patrol also talked about how there are a lot of unknowns. We know the cameras are not that effective. We know people know where to avoid detection. They know how to avoid detection. They know where our cameras are. So there's a lot that goes on that goes unseen and unknown by Border Patrol. They see signs of it, they know it's out there, but they're not able to respond and they're not able to make apprehensions all the time. This is what's going on in Mr. Kelly's life during the lead up to this incident on January 30th. The state talks about text messages that Mr. Kelly sends between himself and his friend, Gary Miller, a very close friend who he's known for a very long time. This is somebody who Mr. Kelly trusts and who understands where Mr. Kelly's coming from. Those messages come in that context. Those messages also come in the context of Mr. Kelly receiving continuously information from Jeremy Morcell, the Border Patrol Ranch Liaison. Jeremy Morcell is continuously communicating with Mr. Kelly about large groups on his property. They're nearby. Be careful. We're working a group of this size. It's in your area. It might come your way. They might be carrying narcotics. Narcotics trafficking has picked up around Kino Springs. This is the communication that Mr. Kelly is receiving on a regular basis from Border Patrol. Border Patrol knows what they're talking about. Mr. Kelly relies on that information. The level of fear and concern that Mr. Kelly experiences on his own property is increasing as a result. He chooses to arm himself in case he ever has to defend himself. And he expresses that to his friend, Gary Miller. He talks about the fear. He talks about what's happening on his property. He does it in an over-exaggerated way to help him blow off some steam, to help him feel a little bit better, and to help assuage some of the concerns that he has, because he never knows when something is going to happen. And ultimately, something does happen on January 30th of 2023. Mr. Kelly is in his kitchen eating lunch. It's a day like any other. He's been out about on his ranch. He's planning to do some more chores for the rest of the day. He has no idea that he's about to be in a life or death situation. He doesn't ask for it. He's minding his own business in his own house, when suddenly he sees something. He sees people carrying rifles, carrying backpacks out the kitchen window. He does the right thing. He calls law enforcement. He is not some sort of vigilante who decides he's going to take matters completely into his own hands. He calls for help. He calls the guy who has the badge and the gun. He calls Jeremy Morcell. And he tells him, I hear a shot or something's shooting. I might have to return fire. Immediately, he tells law enforcement that he may have to fire. When he's walking outside, he has heard a shot. This is not a mystery shot, as the state describes. This is a real shot. Mr. Kelly hears it, and the whole situation completely changes in that moment. A gunshot outside of your home is not something you hear every day. And it's not something you hear in the same context with people running with rifles and backpacks across your property. This is a frightening, scary situation. And in frightening, scary situations, people flee, people freeze, or people act. And Mr. Kelly acted. He is being confronted on his own property, in his own house, with criminal activity involving guns in his yard. And he doesn't know what's going to happen next. He knows he needs help, so he calls Border Patrol. But he doesn't know how long it's going to take them to get there. And he doesn't know what these people are going to do in the meantime. The state would have you believe that you have to stay in your house in a situation like that. You do not. The law does not require that you stay inside of your house. In fact, that is not the smart thing to do. Mr. Kelly, when he walks outside with his rifle, his intention is to stop this threat. His intention is to make these people go away. Because if you stay inside your house, you don't know what they are going to do. They're going this direction right now, but after you lose sight of them, who knows where they're going to go? Who knows what they're going to do? This isn't a conscious thought process that Mr. Kelly went through at this time either. This was a split-second decision. He sees a threat, he responds to the threat. Mr. Kelly is the man of his house. His wife is there. He needs to protect himself, and he needs to protect his wife, just like every man should do. And he is 100% justified in walking outside to meet this threat. When he walks outside, he sees people. He sees that they are carrying rifles. He walks out onto his porch. The metal door bangs behind him. It makes a noise. The person in front looks at him and points his rifle at him. Mr. Kelly tells this to Detective Einstein. He points his rifle at me. Under those circumstances, Mr. Kelly is 100% justified in firing his weapon at that person. He doesn't need to fire warning shots. He is justified.
Guys, listen to her versus him. Bouncing from topic to topic to topic. She is like a machine gun. She's like a cruise missile, just laser focused in. And it's coherent. The merits of the arguments regardless, her presentation is far more confident.
In firing at that person in that moment. Again, split-second decision. Mr. Kelly doesn't think, now I'm going to fire some warning shots in the hopes that I will have to avoid doing something else. There is no thought process. This is an immediate life or death scenario. It's an immediate decision that Mr. Kelly makes, and he chooses to not take that shot. He chooses not to fire at that person. Instead, he raises his rifle up above the tree in front of him. And you all have seen the tree. You've been to the patio. You know what this looks like. He raises it up. He fires warning shots. The state said he could have emptied this magazine. He doesn't. He stopped shooting because these people start to run away. He has some more conversations with Agent Morcell about this. These folks are going somewhere. They're gone. The threat is over. He goes out to check on his barn, and he encounters Border Patrol. He has already told Agent Morcell that he was going to fire shots. As far as Mr. Kelly knows, Agent Morcell has passed on that information to everybody else who's responding. He is not required to tell every single law enforcement member every single thing that happened to him that day. He assumes that they already know because he already reported it, and that is why they're there. During this encounter, sheriff's deputies have some communication with Mr. Kelly. They have some communication with Alan, Mr. Kelly, and they start to search this area east of the house. You heard testimony from these deputies. They're searching this area east of the house. Border Patrol is traveling south. Everybody says, we're looking for Mr. Kelly. And Wanda said that he went south. And yet the sheriff's department are searching east of the house. Why are they searching east of the house? They say they're just looking for Mr. Kelly. It's because Wanda told them this is where we saw those people. And so they're searching east of the house to try to find evidence of the folks who Mr. and Mrs. Kelly described. They comb through that area. They go over the two fences. They spread out. They're looking for people. They're looking for weapons. They're looking for people who might be injured or who might be hiding. And they don't find anybody. They don't find anybody. Ultimately, they come back and they talk to Mr. Kelly and his wife. And Mr. Kelly and his wife say, this is the area where we saw people. Mr. Kelly tells them, I heard a shot. He hears a shot and he sees people running with backpacks and rifles. And law enforcement chooses not to go and look again. They don't think it's important. They don't think it's worth it to try to go see if they can find something else now that they have more information. They don't sit down with Mrs. Kelly. They don't tell her, slow down a minute. Let's walk through this one step at a time. Tell me what you saw. Tell me what you did. Tell me where you were. They don't do that with Mr. Kelly either. They don't bother to slow down and get the information. They describe Wanda as being upset. Castañeda, Deputy Castañeda, who talked to Wanda, said she seemed upset. She seemed confused. She was distraught by what was happening. And yet, nobody took the time to ask her to take a breath, to slow down. Let's talk through this. Same thing with Mr. Kelly. He's just had this encounter. Imagine you're sitting in your kitchen and you hear a shot and you see what's happening and all this happens. Your adrenaline goes up. Your whole body is on alert when something like this happens. And when law enforcement gets there, it's still sort of coming down. It's still kind of washing out of you. Under those circumstances, people can't be expected. People who are victims of crimes, like Mr. and Mrs. Kelly were that day, they can't be expected to fully and clearly, from beginning to end, articulate to law enforcement exactly what happened. Law enforcement is trained to deal with that. Law enforcement should recognize that and talk to someone. Talk me through it slowly. That's all they had to do. Nobody did that. And now the fact that Mr. Kelly made some omissions because he's in that state of fear and agitation and adrenaline and excitement, that's being held against him. And that shouldn't be held against him. That should be held against the officers who didn't properly recognize the situation, who didn't ask questions of witnesses. You heard the state argue this was an emergency call, lights and sirens, active shooter. Law enforcement was on high alert when they came to the scene. They had their rifles out. And yet they failed to recognize that Mr. and Mrs. Kelly might be in a state of emotional agitation, to put it mildly. They don't recognize that. They don't do a slow walk through of the information. They don't take their time. They don't even go do another search. And now we are left with questions. We do not know if Gabriel Cuen-Buitimea's body was there when law enforcement arrived. It's a question that's outstanding. We don't know the answer to it, and now we never will. Ultimately, law enforcement leaves, and later in the evening, Alan finds this body on his property. This is the second time this day that things have gone from normal and regular to high anxiety, high stress, extreme situation happening here. I've never discovered a dead body on my property. You folks probably haven't either. But who's to say how any of us is going to react when we come upon something like that? How are we supposed to feel? What are we supposed to think? What is an appropriate response to finding a dead person on your property? And imagine what must be going through this man's head. He knows what happened earlier. He knows what he saw. He knows what he did. He knows he fired shots up over the tree in front of his patio, and now he's stumbling upon a person, and he doesn't know what happened. He's a smart man, and he can put two and two together. And any intelligent person who's in his situation, imagine being in a situation where you fired shots and you know you didn't shoot this person, but you know you fired shots. That is scary. Anybody in Alan's shoes is going to be thinking, oh my Lord, what are they going to think when I call this in? It's a terrifying scenario for Alan. What would a guilty person do? What would someone do who's come across this body and who thinks, I probably shot this guy? What would a guilty person do in Alan's shoes? Someone with a huge, expansive property, someone who knows law enforcement was already here and they left, someone who knows that's where I was standing when I fired these shots. A guilty person had every opportunity to cover this up, and he would have been able to do so effectively. He could have disposed of the weapon. He could have picked up the shell casings. He even could have disposed of the body on this property. He didn't even need to do that. He could have just picked up the weapon, hid it, buried it somewhere, buried the shell casing somewhere, and never made a phone call and just left on a trip for a while. That's all he had to do. That's all a guilty person had to do. That's not what Alan did. Alan, even though he's standing there and even though he knows this looks bad, I don't know what's going to happen, he does the right thing. He does the right thing because it's the right thing. You can tell when he's having these phone calls. In the state, they pull up some excerpts and they read them in their tone of voice. I encourage you to review these phone calls and listen to Alan's tone of voice. Listen to his demeanor, hear what he's saying. Is this a person who knows that he's guilty and is trying to cover things up, but nevertheless is calling law enforcement, which is what the state wants you to think? Or is this a person who is completely scared and shell-shocked because he knows he didn't do this, but he knows that calling it in is the right thing to do? And he trusts that law enforcement is going to do the right thing. He trusts that they are going to listen to him. And so he calls it in. He calls the Border Patrol, the guy with the badge and the gun, the guy who he called earlier, the same guy who sent all the deputies out earlier and who sent Border Patrol out earlier. There's no possibility that Alan thinks the Border Patrol is going to sweep this under the rug. No possibility whatsoever that he thinks that. He's still in a distraught state. He still doesn't know how he feels. He's still communicating in a vague way to Agent Morcell because he is in shock. What's the appropriate response when you find a dead body on your property? Can anyone say, here's how you're supposed to act, and if you act differently, then that's wrong? People act in all sorts of ways when confronted with shocking and frightening scenarios. And Alan couldn't form the words. He called for help, and he tried. He tried to communicate what he was finding, and he did. You cannot listen to these phone calls with, well, there aren't phone calls recorded with Border Patrol, unfortunately. You can't listen to the phone call that Alan has with the Sheriff's Department and conclude that he's not communicating that there is a dead body on his property. He makes it very clear with the words that he can call to mind in that moment, which is a terrible moment for Mr. Kelly. There's a lot made about the phrase animal or the use of the word animal. Agent Morcell testified that he used that word first. He asked Mr. Kelly, what is it, Mr. Kelly? You're not telling me what's going on. Is there an animal? And Mr. Kelly responded to him and said, well, as opposed to a vegetable or a mineral, if you know what I mean, he's clear. He's making himself clear. And then he does the same thing when he's on the phone call with the Sheriff's Department. Something that else goes to Mr. Kelly's mind when he's talking with the Sheriff's Department is the Sheriff's Department dispatcher tells him, you said you shot something. The dispatcher tells that to Mr. Kelly when he has never said anything like that. Again, imagine how must somebody feel knowing I fired shots earlier. I know I didn't hit this person. Here's a dead body. Oh, I'm afraid to call this in, but I have to call it in. And then when dispatch talks to him, dispatch says, you said you shot something. That is terrifying. That is a terrifying mistake that dispatch made, and it's terrifying for Alan to hear that. That's all in his mind when law enforcement is responding to his property. That's also all in the minds of all of the law enforcement personnel who are going to this property. They are being told incorrectly that Alan stated he struck something or he shot something when Alan never made that statement. And it's nobody's fault. Alan's on the phone with Agent Morcell. Agent Morcell is on the phone with Agent Tercey. Agent Tercey is relaying that to Agent Layugan. Agent Layugan is relaying that out to the Sheriff's Department. So you have all of these layers of telephone. And of course, things get lost in translation. It's not necessarily anybody's fault, but it is a crucial defining factor in this case. The investigators go out there already believing that this guy has confessed. They already have their suspect before they arrive at the scene. When they're at the scene, Lopez, the first person who comes out, he talks to Alan. He finally records a conversation. And his recording shows that his report was wrong. This is a theme that comes up repeatedly in this case. Law enforcement documents statements, especially Alan's statements, especially Wanda's statements, incorrectly. We have two reports from the first call from two different officers who both at the same time talked to Mrs. Kelly. And they both say that she said two completely different things. None of these conversations are recorded. Documentation is unreliable. The conversations between Mr. Kelly and Agent Morcell, not recorded, unreliable documentation. Finally, when we have a recording, it's Lopez, first person on the scene, he records him. And Lopez documents that conversation incorrectly in his report as well. According to Lopez's report, he says to Mr. Kelly, "Do you know if you shot him?" And Mr. Kelly says, "I have no idea." That sounds pretty bad. Sounds like Mr. Kelly's admitting he might have shot this person. That is not what Mr. Kelly said. When you listen to Lopez's recording, the recording says, "Do you know who shot him?" And Mr. Kelly says, "I have no idea." Very, very different. The documentation of the statements made in this case is really concerning to anybody who's worried about law enforcement being objective. You have Omar Rodriguez who gets out and stands near the body. He's looking at the body. He's got this in his mind, and he speculates about the angle of the shot, the same way that you heard the state speculate in their argument to you about the angle of the shot. He says this shot comes in here, goes out here, there's the house over there, aha, the shot must have come from there. That's not what any of the experts say. The experts say you have no idea, based on this evidence, where this shot came from. We're going to get to them in a minute, but the initial investigators feel very free to speculate. You have Sergeant Flores, who takes photographs of the body. There's no note that the backpack is unzipped. Nobody raises that as an issue in any reports. Nobody raises the issue about how the backpack's pulled up over this person's head. Nobody raises the issue about how the fanny pack buckle is broken and the fanny pack is lying next to this person. There are photographs, we can see those things, but nobody seemed concerned about that. Nobody seemed to think maybe there are other crimes that have taken place here besides the obvious crime of this person's been shot. Nobody ever considered that there was any other evidence of any other crimes. Sergeant Flores on the stand specifically said, "No, I didn't see any evidence of any crime. None." Amazing. It's amazing. Think more about the emotional aspect of this. These are human beings. Alan's a human being, Wanda's a human being. We're not robots. We all react differently in different situations. Alan's on scene. Nobody's talked to him. Still, nobody's asked him, "Walk me through what happened. Show me where you were." Nobody does that. And then they put handcuffs on him. And they put him into a police car. Imagine what he must be thinking in that moment. Imagine just that feeling of, oh my gosh, this is really real now. They're taking me away in handcuffs from my house. I don't know if I'm coming back. That's an unbelievable moment for anybody to have to go through. Imagine Wanda. She's been sitting in the back of a police car. They don't ask her what happened. They don't walk her through the scene. They don't ask her anything. They put her in the back of a police car. Wanda, a person who has obviously never done anything wrong, who's obviously a victim of a crime. They put her in a police car. They take her to the station. That's an arrest. They arrest Wanda. They don't have any reason to do that. And right before they drive away with her, she sees her husband walking past the car in handcuffs. How does she feel when she's being taken to this interview? How does Alan feel when he's being taken to this interview? Would it be reasonable to be scared? Of course it would be. Would it be reasonable to be really concerned now? Maybe I don't really trust these investigators. I'm in handcuffs when I called them. That's a big concern. This is what's going on emotionally when Alan and Wanda are interviewed by law enforcement. And again, there's no slow walkthrough. There's no show me on a map where this is. What did you do? Describe this to me. Wait, let me back you up a little bit. Tell me more about this. They don't do any of that. There's browbeating. There's tactics used to try to scare this man into confessing. Detective Einsa tells him, you shot this person. That's pretty scary, especially if you know you didn't shoot this person. There's, we're going to find that rifle and we're going to do ballistics. By the way, what's Alan's response to that? He says, you don't need a search warrant. I will show you where the rifle is. I will show you where the rifle is. This rifle that's supposedly not in its proper place, according to these guys. Alan says, I will show you where this rifle is. Detective Einsa says, no. Fair enough, okay? Then we get to significant issues of words being changed, and this starts with Alan. He's in this interview with Detective Einsa, and watch it. Don't pick out a line here or there. Watch it. You have the whole interview. Look at the whole thing beginning to end. Listen to the context. Listen to the tone of voice, the body language. It's a whole. Don't pick out a line and decide what it says. Watch it. Repeatedly, Detective Einsa says, you shot this person. You shot at these people. Alan says, no, I never did that. The state talked about a part in that interview where he was asked, did you shoot? And he doesn't answer. Watch the interview. Detective Barba asks him, did you shoot? Alan pauses, and then Detective Einsa jumps in with a different question, and Alan answers that question. He never denies having shot his rifle, ever. He's asked, he says, yes, I shot this rifle. I shot it up. I shot it over. Detective Einsa says, at, over, same thing. Alan says, no, it's not the same thing. It's a different thing. And there's back and forth about that a lot. Alan obviously thinks at and over are two different things. Alan also repeatedly says, I never chased anybody. I never went after anybody. I don't know where you're getting that. Watch the interview. It's there. In spite of this, law enforcement essentially fabricates a confession. They write down on the booking form. That booking form is their statement of probable cause. Here's what happened. Subject, he was chasing people. He shot. He admitted he shot at multiple subjects. That was not true. Alan never said that. Law enforcement wasn't listening, and they didn't care. They already decided that he was guilty, and they were perfectly fine inventing words for him, words that were the opposite of what he said and putting those down as if he said them. There's a lot made about Wanda. The treatment of Wanda in this case was just disgraceful. They're trying to say that she's lying to protect her husband. She said 5 and then she said 2. They come up with these extremely nitpicked, not recorded, supposed inconsistent statements to say that she's lying. I would just submit to you that if Wanda were lying about what happened in this case, all she would have to do would be to say, I saw these guys, he pointed a rifle at my husband. That's all she would have to say. She didn't say that because she didn't see. But if she wanted to lie about something to protect Alan, very easy for her to do. That's all she would have to say, and nobody could contradict her. She didn't do it. So confirmation bias is a big thing that runs through this case, and it's the tendency to interpret new information and new evidence to confirm pre-existing beliefs and conclusions. And that plays a very big role in this case too. They do this interview with Alan, they don't listen to the words he says, they make up new words, and they arrest him. They don't wait until they can do ballistics. They don't wait until maybe they can find some witnesses. They don't wait until they can do forensic testing or any drone footage or anything.
Guys, I just need to say, notice the state can't really jump up and say, Your Honor, they didn't fabricate a confession because the evidence clearly shows they did. This is phenomenal work. She is just on a roll, guys.
They don't wait. They just go straight for this guy. And every single thing that they do after that, they design to confirm the decision that they've already made. It's natural. Human beings, we like to confirm that we're right. It's really uncomfortable to say I might have made a mistake. Maybe I was wrong. And so when they get a phone call from somebody calling himself Miguel, who says he's related to the family, they don't question it. And then when it turns out that that's false, well, oh well. They're not concerned that people are coming forward making false statements about this case, even though apparently they've talked about it, I don't know. But it doesn't bother them. Then there's this person, Ramon, and he says something different. He comes forward under different circumstances too. Does anybody bother to analyze his statements? Does anybody bother to compare his statements against Miguel's statements or Mr. Kelly's statements? Does anybody bother to compare Ramon's statements to the physical evidence in this case? No, of course not. They don't need to. They have their guy. They have their conclusion. Then we get to Daniel. The state says he makes consistent statements. And remember, if you're inconsistent, that means you might be lying about something. Well, Daniel doesn't even tell investigators what his name is in this case. He comes forward under very suspicious circumstances. He comes forward after this has all been out, after they know that Mr. Kelly's been arrested. His picture's been all over the place. Their version of events is out there for anyone to read, for anybody to think about, for anybody to make something up about. And here comes Daniel. And he lies about his name because he doesn't want to get deported back to Honduras. And he lies about his criminal history. He's asked, have you ever smuggled drugs in the United States? He says no. That is not true. He's telling a lie. The state says he's not associated with any criminal organization. He's not a drug smuggler. Daniel says, I'm not a drug smuggler. Well, except for when he is, because he took a plea in federal court under oath to smuggling drugs. Lied about his name to federal court also, by the way. You hear from law enforcement that you can't just accept a statement as the truth just because it's a statement. You have to test its credibility. You have to see if it matches up with other statements, with physical evidence, with known facts of the case, with forensic evidence. And that's how you can assess the reliability of a witness statement. I'm not going to get the whiteboard out again. You guys have seen me do it already, but you've got a body found 115 yards east of Mr. Kelly's house. You've got that body lying face down. You've got Daniel stating, we were 10 meters away from the house. We were to the west of the house. We were facing the border wall. Border wall is 2 football fields away. The shots were coming from over there away from the house. That is impossible to believe. It could not have happened that way. We know for a fact, we're not guessing, we know for a fact that it did not happen the way that Daniel said that it happened. We know for a fact that Daniel previously told investigators he was 15 meters away from the border wall when this happened. We know that for a fact. State says he's consistent. How is that consistent? It's not. We know for a fact that Daniel claims he gets right up to that road that goes by the border wall where the pines are. I looked back, I saw the person. We know that for a fact. We know that that is impossible. You all have been out there. You know what the end of the wall looks like. You know what this road looks like. That is impossible. We are not guessing about that. That is a fact. We know that the body's not on the west side of the house. Fact. We know that the body is not 10 yards away from the house. Fact. We know that there is no Border Patrol road that goes through this property that goes directly to the end of the wall, like Daniel said it did. Fact. We know he is wrong. What does that mean? It means he wasn't there. It means he is telling a story. Why? We don't know. But you can't be there and get it this wrong. It is not possible. I don't care if you have a 6th grade education. My kid has a 3rd grade education, and she can describe a place. It's not that hard. Nobody questions this either. Forget what Daniel says for a minute and how obviously false and concerning that is. What is wrong with the investigators in this case? Raul Rodriguez interviews Daniel, and he says things that Detective Rodriguez admits, these are not making sense. Instead of pursuing that, for example, he says this took place west of Nogales. No, it didn't. We know that for a fact. It took place east of Nogales. Instead of pursuing that as a possible problem, as a possible, maybe this person's not so credible, maybe they have another motive for coming forward, law enforcement doesn't bother asking any questions. Instead, they provide explanations. They provide help. They provide suggestion. They say, well, are you sure you were that close? That sounds pretty close. Are you sure? Well, maybe you don't know because you were running and maybe you were scared, and so you didn't really know where you were, right? They make suggestive statements to this witness in an interview, when really they should be suspicious about this and they should do some detective work to find out what the truth is, not to bolster what they've already decided they want the truth to be. That's not how an investigation should work. And let's remember, Daniel first comes forward because the sheriff goes into
What? Hold on. Whoa. What's happening here? I didn't do anything.
Why is the sheriff going into Mexico? Why? He doesn't wear a uniform because if you wear your uniform in Mexico, they get picky about that. That's what he said. It's quite the euphemism. And then they don't record this interview, and then they record part of it, and they've got no good reason for why they did that. That is sketchy. And that sets the tone for this whole investigation. So that's some of the facts, that's some of the evidence that you've heard from this witness. Let's talk about the forensics. The medical examiner's report essentially says there's no way to determine the time of death. This is a very significant fact in this case. What was the time of death? Because if his body wasn't there when the sheriff's department searched this area, then Alan has nothing to do with this. We have evidence that Omar Rodriguez examined the body. He says the torso is still warm. This is significant information. He could have passed that on to a medical examiner to get some sort of scientific determination of time of death. Didn't do that. They put the body in a cooler. They destroy any possibility of accurately determining a time of death scientifically. And the medical examiner's report proves that a gunshot wound is the cause of death. It doesn't prove which gun, doesn't prove which type of gun, doesn't prove which type of ammunition, doesn't prove even long gun or handgun, doesn't prove anything other than gunshot wound. Okay, great. The ballistics. Let's talk about that. See what can be proved in this case, what they did prove forensically. They talk about this as a long-range shot. I recall the ballistics experts testifying that what that means is this shot was fired from a distance of 6 feet away or further. That's a long-range shot. So they've proven that this shot was taken from 6 feet away or further. Anything in between is a guess, and we are not supposed to guess. The ballistics, obviously there's no bullet, so they can't prove which weapon this came from. They can't prove which type of weapon this came from. They can't prove, again, which type of ammunition this came from. The shell casings, we heard testimony about shell casings that are found on the patio. They can't prove which direction the shooter was pointing. You make a circle around the shell casing. The shooter could be standing anywhere in that circle. They can't prove if the shooter was pointing straight or up or something else. Interestingly, the ballistics experts testified that had they been told that there was a possibility that this rifle was shot in an upward direction, they could have done testing on the shell casing pattern. And they might have been able to come to a conclusion about that. Yes, it was pointing up, or no, or it's inconclusive. But they didn't do the test because they were never asked to by the state. The investigators in this case never tested their own theory. They never considered that what Alan said might actually be supported by some evidence, and maybe we should look for that evidence too, not just evidence that shows that he's guilty. They didn't do that, and now we'll never know. Imagine if this were a sexual assault case and there was DNA of the perpetrator involved, and the investigators said, well, we could test that DNA, but it'll probably be inconclusive, so we're not going to test it. That's outrageous. That is outrageous. We have a right to expect that people who are investigating people for serious crimes are going to examine and test every piece of evidence that they can, even if it might not tell them something. What if it could? What if they did that test? What if it showed that an expert could say this rifle was pointed in an upward direction? It could do that. We would want to know that, wouldn't we? Before we decide what happened in this case. They didn't do it. The ballistics also, you've got this field of obstacles in between the porch and where this body is eventually located. You've seen the photographs, you've been to the scene, you know how many things are in between there. What I didn't hear the state address is the problem of the point of aim and the point of impact for this rifle. I'm not going to rehash all of that, but ballistics experts said that if that entry wound, and this is assuming the person's just standing there, we have no idea where this person was when he was shot. The ballistics experts testified that they could not possibly determine that based on the evidence that they saw. But the point of impact on this person was about 4 feet off the ground, which according to the experts means Alan would have to been aiming, if he took the shot, at a spot that's about 3 feet off the ground, which means he's aiming down. And you saw everything that was in the way. You saw the smoker, the pergola, the patio, the table and the chairs that's on there that's made out of cement. If he were firing in that manner, there would be evidence. The fact that there's no evidence of any bullet impacting anything in that entire field is evidence that supports what Alan said happened. If he fired where he said he fired, of course you don't expect to see bullet evidence in that field of obstacles, and you don't. The physical ballistics evidence is consistent with what Mr. Kelly said happened in this case.
Ms. Larkin?
Yes.
It's about 5 to noon. I think it's appropriate. It looks like you're moving into a new area, so it's a good time to break. We'll take our noon recess. Same routine as we've been following all week long. We'll take a noon recess and go out to lunch. Please be back in the jury room at 1:30, at which
All right, guys, we're going to switch over to
time the defense will continue with this closing argument. We're on recess until 1.
Okay, so we're going to go back out to K-Gun here. This is part 2 of the defense's closing. The state does a rebuttal, and it's weird you don't see it here. Even when you look through all their videos, they don't have it, which is very concerning. But we are going to, there's another channel that apparently, Recovery Addict, he got their closing he got the rebuttal argument, which is weird that he found it, but I don't know, whatever. We're going to listen to it, so we are going to get caught up on everything, guys. So just hang tight here.
And Ms. Larkin, you can continue.
Also, is anybody else convinced that George Kelly did it so far? No, I don't think so.
With the defense closing argument.
I just have a few more points to make before I let you go, so I'm going to try not to take up more of your time. I know you guys have been very attentive, and we appreciate that. I just wanted to talk first about some of the characteristics that we observed on the victim, Gabriel, in this case. You saw the radio, you saw the binocular.
And actually, before we get going, I need to answer these just because they were here. Debbie with the super chat for $20. Thank you so very much. I do appreciate the support. Says, would you assume the prosecutor's office thinks this guy is their strongest storyteller, and that's why he's doing closing? Or could there be other reasons he do it? I don't think he's hitting the mark yet, at least. No, because you generally just can't bring in like somebody at the end. And for the most part, for prosecutors, like I said, you're playing on easy mode. Generally, you've got somebody who has confessed. You do have a lot of evidence that's in your favor. This one's a tougher one for him because they don't have all that stuff they normally do. This is one of these cases that is not going their way. You know, when everything lines up, it's pretty easy to tell a coherent story. And that's how you notice the defense having an easy time. They're playing easy mode, actually. They're closing arguments easy mode. They're laying it out. I think this would be a tough one even for me to put together. Kelly's saying, must you yell at a warning? No, you don't have to yell a warning. That call's not helping the prosecution. I agree. Yeah, yes, and Bob says El Wallo di Trumpo. So, but yes, Debbie, a lot of prosecutors think they're good storytellers, but they really aren't. They're good at telling pretty coherent stories. When we watch these trials, you defense attorneys weave together bits and pieces to make a story. That's storytelling.
You saw the camouflage. You saw the photograph of Gabriel on a different occasion about 9 days prior to these events, wearing the same clothing, also carrying that radio, carrying binoculars, carrying a fanny pack. Could be the same fanny pack, could be different. But all of those things come together. And you heard testimony from Border Patrol who described what they perceive when they're observing somebody who's present in the United States illegally, carrying these sorts of accoutrements. And long story short, this is simply not somebody who's looking for the American dream. There's no evidence that this person is here.
And that's a critical thing, chat. And I'd point, if I was the state, if I was the defense, the neat thing is when you were the state, you can't point out really what the defense said or didn't say. That gets kind of straying the lines of Fifth and Sixth Amendment rights. But as a defense attorney, I'm allowed to point out. Remember this prosecutor telling you at the beginning, these are just guys trying to live the American dream. They just wanted to they're just good boys, didn't do nothing wrong. And we're like, but they weren't. Something was up. I'd be hammering on that.
For those kinds of benign purposes. All of the evidence, in fact, points in the other direction. And we bring that up not, to be judgmental about Gabriel or to not have compassion for him, but when people are involved in criminal lifestyle, it's dangerous. It's more inherently dangerous than simply being a migrant who's coming here. So it's relevant for that reason. I want to talk about what the state is actually asking you to believe, because they haven't really put everything together for you to tell you what happened in this case. And if we assume for a second that what the state is claiming here happened, then we have to try to fit that story into the known facts of this case. And that's always something we have to do. Consider the known facts of the case next to whatever's being presented to you to see if they make sense together. According to the state, Mr. Kelly is standing in his kitchen and he sees somehow out through those windows all the way out 115 yards to where Gabriel's body is eventually located. And he can somehow see that from inside his house.
I don't know if I would say it like that, because you're almost encouraging the theory he had no fucking idea what was going on out there. I wouldn't have said it like somehow. You would say he could. I wouldn't even say somehow. I would say he sees them. His loyal wife Wanda says, "Oh my God, there's armed men on the property." I wouldn't say, "Oh, he could kind of see." No, he definitely saw them. He saw armed brigands. He saw the bandidos running wild. Don't use language the state can capitalize on.
You all were there. I'll let you all be the judge of whether it's even possible to see somebody from inside the house. But let's say that he does. And let's say that he sees two unarmed people who are just moving somehow out there. The state wants you to believe that he calls law enforcement and makes up a story about hearing a shot and getting shot at, and he makes up a story about seeing people with backpacks. Then the state wants you to believe that after he makes that call to law enforcement, he picks up his rifle, he goes outside, he takes aim at these people who are posing absolutely no threat to him whatsoever, and he shoots because he just wants to kill somebody on his property. That's what the state wants you to believe happened. And then after that, if the state wants you to believe what Daniel says, they want you to believe that Mr. Kelly somehow crossed over those two fence lines and stood over Gabriel's body while Daniel was running away. They want you to believe that that's what happened. Just ask yourself, does that make sense? That's just the first part of this.
Nope.
Does that make any
Nope,
sense
at all.
when you put it next to the physical evidence in this case and the known facts of this case? They want you to believe that after Mr. Kelly deliberately shoots this person and sees this person on the ground, that he then somehow manages to go over to the area where his barn is after calling and speaking with law enforcement again and telling them he saw people with guns. And then they want you to believe that he brings law enforcement onto his property, law enforcement searches his whole property, law enforcement doesn't find the body in this case, and then law enforcement leaves. If what the state is claiming happened actually happened, that would be the end of it. But that's not the end of it. The state wants you to believe that even after Allen knew he shot this person, did so deliberately, had no threat, no justification whatsoever to do it, called the cops, they left, he calls again because he thinks, you know, I really should just show them where this body is. They want you to believe that he decided a couple hours later to just bring law enforcement back onto his property and take them to the body. And they want you to believe that he did this without in any way trying to cover up any of his involvement in this, without picking up any shell casings, without getting rid of any weapon, and without concealing the body or doing anything like that. They want you to believe that the calm demeanor that they describe on the first call is his demeanor even after he stood over this body and he knows he shot this person. He's calm. But somehow later when he's on the phone with dispatch, he's upset, he's distraught, he doesn't know what to do. I'm just asking you to consider whether any of that makes any sense when we look at the facts on the ground. And it does not. It makes absolutely no sense for this man, if he wanted to go out and shoot somebody, to call law enforcement right before he does it, speak to law enforcement right after he does it, right after he knows he did it, and then bring them back after he knows that they couldn't find the body because they didn't do a thorough enough search. None of that makes any sense when you look at the facts on the ground. What does make sense? Mr. Kelly sees a threat. He sees people with rifles. He calls law enforcement. He goes outside. He fires his warning shots exactly the way that he describes. He sees people moving from left to right. He turns in this direction to the right to fire over that tree that you all saw. Meanwhile, the body is discovered over there. It makes sense that Mr. Kelly did not fire any shots through that thicket in that direction. It makes sense that those shots were fired in the exact direction that he said that they were shot. And it makes sense that he continues to communicate with law enforcement. It makes sense that he's not distraught at this point. Why? Because he has no idea that there's a body there. In fact, we don't know that there is a body there when he calls law enforcement on that first call. It makes sense that he's telling law enforcement what happened and what he saw, and he's continuing to communicate. When he talks to the sheriff's department later, after he's discovered the body, it makes sense that he just discovered the body because of his demeanor in that phone call with the sheriff's department. He is upset and disturbed in a way that he was not earlier on in the day. All of the facts that we know make sense with Mr. Kelly's version of how things happened. They do not make sense with the state's version of how things happened. Nobody deliberately shoots a person right after calling law enforcement for help. And nobody, if they do that, which they don't, nobody lets law enforcement search their property, fail to discover the body, and then call them back later without taking any steps to conceal anything. Nobody does that. That makes absolutely no sense. Wanda Kelly probably picked the best word to describe that scenario, and that is crazy. Nobody does that. The standard in this case, we talked about this at the beginning, is proof beyond a reasonable doubt. This table has that burden. This table has no burden whatsoever. We do not carry any burden of proving to you that George Allen Kelly is not guilty. The state carries the entire burden proving to you that he is guilty. And I mean proof. And in order for you to find Allen guilty of any of these offenses, whether it's second-degree murder or any of the lesser included, manslaughter, negligent homicide, they have to prove to you that Alan shot this person. And they have not done that. The ballistics don't prove it. The witness statements don't prove it. Alan's own statements don't prove it. The facts on the ground do not prove it. They haven't done it. In order to prove the offense of aggravated assault against Daniel Ramirez, Daniel specifically, they have got to prove that Daniel was actually there. It's as simple as that. They cannot prove that Daniel was there. Anybody who is on Mr. Kelly's property, and you folks were all on Mr. Kelly's property, there is no chance that you could describe that property the way that Daniel described that property. This is not the house with the pine trees. That is maybe west of Nogales, maybe east of Nogales, he changes. This is not the house where there's a border patrol road that goes directly to the end of the wall. This is not the house that's either 2 football fields away from the wall or 15 meters away from the wall. That is not a description that anybody could offer of this area who has been there. The only conclusion that can be reached based on Daniel's description of this property is that he wasn't there. And that's just the property. He describes other things too. He describes being 10 meters away from the house when this happens. There is no body that is 10 meters away from the house. That is not possible. He describes the house being on his left. I'm facing south. That puts him to the west. The body is located to the east. Again, not possible. Daniel describes the shots coming from away from the house, towards him and Gabriel. Not possible. You cannot find Mr. Kelly guilty of aggravated assault against Daniel because Daniel was not there. And you cannot find him guilty of any of the offenses, second-degree murder or lesser included, because they did not prove that Alan shot this person, and they have to prove it. Your jury instructions have various justifications. You're going to read about the defense of premises and what's required by law to allow somebody to defend their premises and what steps they can take to do so. You're going to read about self-defense, using physical force, using deadly physical force, and defense of third persons. All of those jury instructions describe what somebody can and what they cannot do when they're confronted with a threat. In this case, if Alan is telling the truth and his is the only version that makes sense with the physical facts that we know and that we're not guessing about, he was confronted with a threat right outside of his home. That was a threat to his life. He had a rifle pointed at him. Under any scenario, he is absolutely justified in using deadly physical force to respond to that threat. He didn't use deadly physical force. He fired shots up into the air, over the tree, over where these people were to get the threat to stop. And as soon as they turned and went the other way, he stopped firing. He didn't empty his magazine. The state's going to tell you that just firing warning shots is reckless, and just because he did that, you should find him guilty of something. That's not what the law says. The law does not say that you cannot use lesser force to defend yourself. The law does not say that when you're out in the middle of nowhere, and you folks were out there, this is not downtown Nogales, this is not a populated area, this is isolated, it is empty. He can fire warning shots to protect himself and to protect his wife. And that's exactly what he did. That's exactly what any man who cares about his wife and his home should do in this situation when faced with the threat that he was faced with. The jury instructions are going to explain to you that the state, besides having the burden of proving that Alan is guilty, they have that burden. They have the burden also of proving that Alan did not act with justification. It's up to them to prove it. It's not the defense's job to prove to you that Alan was justified in his actions. It's up to the state to prove that he was not. And we ask you to hold them to that burden. I told you at the beginning, this is a criminal case. The burden is serious. This is dead serious. And the reason that we have this serious burden of proof in a criminal case is because we really need to know before we hold somebody criminally accountable, Before we go burn somebody at the stake, we have got to know that they are guilty. We can't just have suspicions. We cannot be guessing. We cannot hope that this happened because then maybe this does justice here. No, we have to absolutely know beyond a reasonable doubt that this man is guilty. That burden really requires that you folks are biased in favor of the defendant. If there are two possible interpretations of different pieces of evidence, the defendant gets the benefit of the doubt. That's how the system works. That is how we know you don't want to do something to the wrong person. Justice is not served if the wrong person is held accountable for somebody else's act. It's certainly not justice for Alan to hold the wrong person accountable, and it's not justice for Gabriel to hold the wrong person accountable for his death. Think of the burden of proof like scales. Scales balance like this. We start, the defendant is down here. He has the presumption of innocence. His scale has all of the weight. It is up to this table, it's up to the state to put weight into this other scale so that they're supposed to show you enough evidence that'll move it down, not so it's even, not so it's a little bit this way, but so their case is all the way on the floor and the defendant is now up here. That's the level of evidence that is required. And if they don't meet that, which they did not do in this case, then it's your job to find Mr. Kelly not guilty of these offenses. We want you to make this decision based on the facts, the known facts of the case, not based on subjective guesses about what somebody's words might mean, not based on, let's pick a small line in a transcript. Here, convict him based on this. No, that's not what this burden does. We are not permitted to just cherry pick somebody's words, decide what they mean subjectively, and convict a person because of that. You need facts. That's guessing, that's speculation. You can't guess or speculate. You need facts. And those facts have to be proven to you by this table. I wanted to remind you all again that we're not here to solve the mystery. If you sort through all the facts, you look at all of the evidence, you talk about it, and if you decide, I am not sure what happened here, we don't really know what happened here, that means the verdict must be not guilty. That is what that means. And the fact is, we're probably never going to know what really happened to Gabriel. And we won't know because the investigation in this case jumped to conclusions. They didn't search when they should have. They didn't preserve evidence that they should have. They didn't do tests that they should have. And now we'll never know. And when that's the case, when now we'll never know, that's a not guilty verdict.
That's right.
I just wanted to sort of leave you with what reasonable doubt is.
Good job.
It's not proof beyond any doubt whatsoever, but you have real questions in your mind. If you're thinking, I just don't know, maybe he did, maybe he didn't. There's some evidence to suggest he did. There's some evidence to suggest maybe we're wrong about that. And then there are a lot of question marks and a lot of gaps over here that we don't know. The answer is a not guilty verdict. And if you're sitting back there in the jury room and you have those doubts, even if everybody else is all on board, if you have those doubts, then our system requires a not guilty verdict. We're asking you to have the courage to say no. Doesn't matter if there are any pitchforks or torches or anything involved. If there is doubt in your mind about whether Mr. Kelly did this, you have to have the courage to return a not guilty verdict. If there's any uncertainty at all. And they have to prove it. And I'll just leave this with, we talk about reasonable doubt a lot as lawyers. If there ever was a case where reasonable doubt existed, it is this case. If you put this case into an algorithm and asked a computer, does reasonable doubt exist? The answer is yes. We all live in Santa Cruz County. I live in Santa Cruz County. You folks live in Santa Cruz County. Otherwise, we wouldn't be here today. After reviewing all the evidence in this case, If I were to imagine finding a body on my property someday, hopefully that never happens. If I ever find a body on my property someday and I don't know what happened and I don't know how it got there, I think I'd be considering my options before I called these guys.
Oh!
Thank you for your time.
Ow! Ow! Damn! Oh my god! That was brutal, chat. That was brutal. Oh. Oh. Get fucking wrecked. Get fucking wrecked. I wouldn't be surprised to learn as a juror wearing a vest today. Yeah. Oh. Woo! Fucking. That mic was hot. She had to drop it. It was hot, chat. Fuck. All right, guys. Now we are going to switch over to recovery addict. I think Jay's the name of the guy doing it. Listen, Jay. I am using this because it's available. Guys, recovery addict is a nice channel, does a lot of stuff. You got it, so I need it. My browser's lost connection to screen share audio. You guys hear me? You search your browser if this continues to be a problem. Let's try this so you guys can tell me. His name's Scott? Okay. I thought it was Jay. I don't know. There's so many people out there. You see and hear me, but I don't know if you're going to hear this. Hold on. Can you guys hear all that? I know I'm fine. I know I'm fine. What about hearing this? So, anyway, guys, you don't hear him. Okay. We're just gonna. All right, let's go here. Let's refresh it. You guys don't hear anything? You can't hear any of this? What the fuck? All right, hold on. All right. Hold on. Okay. That's weird. Let's switch back over to this and see if it can hear it. Can you hear this? Chat, can you hear her talking? Please answer. Fuck me running with a shovel here. Okay. I'll be right back. I'm going to close out the browser and start it back up. So give me 1 second. All right, guys, we're back. Sorry about that. You can't hear either one. Well, we'll get this to work now. No, StreamYard's like, we lost the audio. I'm like, okay, well, we'll retry this. We'll retry this. And we'll go from there. I don't know what I did. Or I don't know what happened. Check the volume. No, literally, it said at the top of the screen, we've lost audio feed. You may have to restart your browser. So I've never seen that before. Let's try this again. Tell me if you can hear it.
We would have it no other way. The defendant.
You can go ahead.
Thank you. We just heard that the state has this burden. Of course.
Can you guys hear this? All right. All right, it's back. All right, here we go. Let's just double check here. You guys are. All right, here we go. This is the rebuttal from the prosecution.
Of course we have this burden. And we would have it no other way. The defendant does get the benefit of the doubt. We would have it no other way. It's up to us to prove to you, beyond a reasonable doubt, the defendant committed secondary murder or lesser included an aggravated assault with a deadly weapon. We welcome that burden. We welcome that responsibility. The defense just talked about looking at the facts of a case, and we encourage you to. There's the exhibits, there's the recordings, there's the defendant's interview, everything, call logs, everything. Review it, take your time, massage it, marinate over it, do whatever you need to do. We encourage that.
Marinate over it.
Oh, I was actually going to focus on the massaging part. That's what he does at the truck stops. You know, and I
agree.
Massage and manipulate like the
You
police.
shouldn't guess, just the facts. You must evaluate and decide. From the stand only, no other evidence of what he's thinking. There is no evidence. There's no one had a mind-reading cap of what the defendant's thinking. The only evidence you can consider is from that stand and what has been admitted as an exhibit. Attorney arguments of what the defendant is thinking or not thinking is not evidence. In shock, I'm just going to address a couple of these things. In shock, defense counsel likes to say the defendant was in shock when he found the dead body. Daniel was shot at with an AK-47 9 times, and his friend died before
Should
him.
have been 10 more.
In shock. Talk about the porch door slamming. No evidence from the stand. None. The porch door slammed and made a sound.
He made this
Additionally,
PowerPoint
you were out
during
there.
her closing.
You walked from the living room to the outside. And did you hear a porch door slam? No, you didn't. Security sweep versus search of the property. You heard testimony from the officers. Difference between a security sweep, active shooter going out there making sure, one, preservation of life, making sure they locate Mr. Kelly, and two, find the shooter. It's all over after that. There's no searching of the property because no one knows anyone got hit. There's no searching the property except for an active shooter or the defendant to make sure he's okay. Wanda, on the stand, said these two individuals, Gabriel and Daniel, were walking by. They were walking by. Time of death.
They also said they were walking by.
Sergeant Rodriguez said pronouncement of death 6:24. Death, of course, happens before that. The shooting event is at 2:30. Death happens at 2:30. The view, the shot, the direction, the injury. Look at all the evidence. You saw the view. You know he shot. We got the direction, and we have the injury. Don't guess, just the facts. I agree.
You don't have a lot of facts here, buddy.
Who is Gabriel? You have a photo of him a week and a half earlier, meaning nothing. You know nothing about Gabriel. You guys can't speculate if he's a hunter. He's out there sightseeing, bird hunting. We have no idea what he's doing.
He's sightseeing or bird hunting. He's just a nice boy, chat. He's out there for the Audubon Society. He's out there getting things ready for people coming to visit. He's just prepping things. You don't know. Y'all don't know what he's doing. Oh, come on. Come on. He's seriously saying this shit with a straight face, too.
And on the day of January 30th, he didn't have binoculars.
How do
There's
you
no
know?
evidence of him having binoculars.
How do you
he doesn't
know?
have a radio. That's not uncommon for migrants coming into the United States to coordinate pickups once they come to the country to communicate with a driver to get picked up. That's not uncommon. Then they said a guilty person wouldn't do X, Y, and Z. Well, the defendant lives on a property where VP couldn't tell us how many, but we do know there's a lot of cameras out there. So imagine the defendant shooting someone and proceeding to dig a grave to put a body in. He's going to be caught on film. Of course he's not going to do that. Daniel, consistent in AK-47, consistent on a red horse, consistent on the position of Gabriel when he was shot. Not possible that he was there? None of this information was known. So Daniel comes in and tells us about it. His reported false name, he owned everything. You heard on the testimony, he came in from Honduras to Mexico, and that's the name they gave him when he was a boy. He's never hidden that fact. He took a guilty verdict, conviction in federal court with that name. He never once hid from that fact.
Okay.
I want to talk about this because defense counsel argued, the defense counsel argued, I might have to shoot back. That's not what he says. He says, I'm being shot at, I'm shooting back. He doesn't say, I might have to shoot back. He says, I am shooting back. Some of you guys may be familiar with Occam's razor. Sometimes the easiest answer is the right answer. Right? You've got two options here. This tale of 5 armed men, bandits, walking the property, shooting, not shooting, dangerous, not dangerous, backpacks, not backpacks, or what the facts say. Defendant sees 2 guys walking his property, unarmed.
Is he now arguing that the other witnesses were wrong? Is he arguing these other witnesses that nobody kind of like quasi-interviewed are all liars? Is he saying these other Mexican guys, there weren't really 5 of them? Don't they introduce all that test, like all these other guys said it happened? Come on now. Like, are you trying to tell me that I didn't fucking hear that?
Goes on the patio with his AK, no warning, and shoots 9 times. And hits Gabriel on the side. Sometimes the easiest answer is the right answer. We just went through this. This is the toughest job you'll ever have. It will. It is. This isn't about the character of him as a person. It's not. We're not making a judgment call about him and his life. We're not. This isn't judging his life. This is about the conduct on January 30th, 2023, and that's it. Just the conduct on January 30th, 2003. How many windmills do we chase? How many? Do we chase?
You don't chase windmills. You joust at them. I mean, fuck, dude. You're like, I'm gonna talk about some Don Quixote. That's some Espanol related cultural things. He didn't chase windmills. He attacked them. He jousted them.
Armed gunmen. There's no BP footage, no foot traffic, No other shell casings found on scene. No one heard the mysterious shot. No evidence of drugs, guns, backpacks, a struggle, body dragging, blood trail. No evidence of any of that. None. No evidence of a group crew. How many windmills do we chase? And the answer is obvious. If your goal is to get trespassers off your property and they are already moving off your property, question, why shoot? If your goal here is to warn off cartel members who are already moving off your property, if this boogeyman up to 15 members with guns, the question is, why shoot at them? And finally, if your goal is to protect yourself, and if someone points a gun at you, why are you shooting in the air then? If someone points a gun at you, why are you shooting in the air? Shoot back. Lugan, BP agent Marcel. Defendant said to Marcel, who told him, I struck something. You remember the testimony on the stand? When they tried to cross-examine him about something different? And Lugan, Agent Lugan said, that's the first time I heard that. He testified. Defendant says he was told by Marcel, I struck something.
Yeah.
Remember defense opening. We claimed Detective Ienza was hostile. We heard it today. He browbeat the defendant.
Yeah, he did.
No such thing happened.
You're telling me that didn't happen? He didn't sit there and say, I know you're lying, and then it turns out, oh, wait, I had it wrong all along? I'd love to hear him. I'd love to sit that guy down in a room and say, so you're telling me this part didn't happen?
Professionalism. Ienza first starts out by telling me, question, tell me everything you know. Very open-ended question and sat quietly. You have the interview. If you don't believe me, watch it.
He means chasing red
Ask
herrings.
them anything you want to ask, anything that is important that's going to help out and assist me in clearing this out.
He's chasing red
Defendant
herrings.
responds, I don't know. I think we've been very professional, Ienza, and I thank you. I haven't been disrespectful to you. His answer is no, you haven't. There's no browbeating going on here. Ienza, I'm not here to disrespect you. I haven't been disrespectful. Question. Answer. No, you haven't. When they leave that interview, they handshake. There's no browbeating here. It's a voluntary statement by the defendant. Ienza, is there anything else you want to answer? Is there anything else you want to tell me before we end? I'm thinking. He's asking open-ended questions to the defendant. He wants to get to the bottom of this. Justification instructions, we saw this. There's 5 of them. Remember, it's a reasonable person standard. It's not a defendant standard. It's a reasonable person standard. No evidence of any armed gunmen, no BP footage, no foot traffic. We talked about this. No one heard the mysterious shot. No evidence of a robbery, dragging, anything of the sort. None. There's no justification seeing 2 armed gunmen walking 2 fences away, 115 yards, pulling out your AK-47, stepping on the patio, no verbal warning, and shooting 9 times. No justification for that whatsoever. Important 2 concepts. We just talked about reasonable person standard. He escalates the situation. His wife is fine. She testified. She didn't grab her gun. She didn't lock windows. She didn't lock doors. There's no danger here.
Stood between the windows so she
Justification.
couldn't be seen.
You do have the right not to retreat. You do. We don't argue that. However, you do not have the right to use deadly physical force to protect a person who didn't need protecting. And you don't have the right to use deadly force when there is no threat to home or yard. And you don't have the right to initiate, instigate, or escalate with deadly force. No right whatsoever. Reasonable doubt, we just talked about that. Leaves you firmly convinced. We don't know everything with absolute certainty, but it leaves you firmly convinced. Use your common sense and everyday judgment. It's not a mystical thing here. Firmly convinced, and nothing is known with absolute certainty. Use your best judgment.
Okay. Yeah, I'm using
No
my
guessing, just the facts, and we'll end with this. Gabriel and Daniel were shot at. Gabriel is dead, killed by a high-powered weapon, an AK-47. Entry wound, exit wound, lined up with the defendant's property. Defendant's words, is a typo inconsistent with the physical evidence. Inconsistent. The victim's
typo
statements,
says consistent.
Steps
Defendant's
out,
words consistent
no verbal
with
warning.
physical evidence.
Defendant shot his AK
It's a
9
Freudian
times.
slip, chat.
Shell casings prove it. Ejection pattern
It's a
proves
Freudian
where he was
slip.
standing. Position and orientation of Gabriel's body proves where the shot comes from. The state's going to ask you to find him guilty of second-degree murder. We also have, if you don't agree, manslaughter. If you don't agree with second degree or manslaughter, you can find him negligent homicide. And also find him guilty of aggravated assault with a deadly weapon. He manifested everything in this situation. He escalated it. And I'm going to leave with this. The moral of the story, again, is you shot and someone is dead. The answer is yes.
All the places that have a typo. Spell something wrong.
All right, thank you.
Don't
That
argue
concludes
the other
closing
side.
arguments. Ladies and gentlemen of the jury, I need about 5 or 10 minutes just to finish a verdict form. This is the form that I'll give to you when you go back
Well,
to deliberate.
that's
You'll
it,
have
guys.
when you complete your deliberation. So I'm going to stay here. I'm going to excuse you. It should just take 5 or 10 minutes. I'll stay here with the lawyers. We'll excuse the jury.
All right, guys. So he read the instructions, but listen, we already covered the instructions, so I'm not going to go back through them. And also it's weird, because they've just now put it all up on the court website, the morning part, and then the afternoon part still isn't up. So that's why we use that. Scott over at Recovery Act, thank you for letting us borrow that. Thank you. Very nice. I guess I'm kind of asking for forgiveness instead of permission at this point, but oh well. So there you go, guys. There you go. Yeah, we'll do a poll. We'll get the poll up, chat. I know you guys love dancing on the polls. But wow, that was it. That was their best swing at putting George Kelly in prison. And the sad part is, as prosecutors, they can kind of fuck up and it still be good enough. Isn't that the scary part? Isn't that the scariest fucking part of all? I mean, it really should. It really does make you concerned. It really does. It really does. It really does. Makes me concerned. So we'll do a verdict real quick. Now, if you guys have questions, throw them out there. And if you guys are new, my name is Sean, so no potentially criminal. I'm an attorney out in the Cleveland area, and I do criminal defense stuff, among other things. But we just finished George Kelly's trial. If you have questions, go ahead and, throw it up there. We'll answer them. Guilty. Hung jury. So you got 4 options. You have not guilty, guilty of second-degree murder, guilty of a lesser offense, or a hung jury. So that's what you guys got. Let's see what you do. Let's see what you do, chat. My little chattels. My little chattels. What are you guys up to? Her mic drop FU to the state was based. Yes, it was. Yes, it was. Forum 70 does a hung jury. It's good to see you. It's good to see you. It's been a little bit. I know you pop in and out, but it's been a little while, I feel like. Saying, does a hung jury mean an automatic retrial? No. A hung jury means a mistrial, and then it's up to the state to decide what they want to do. Sometimes they will retry things. Sometimes they'll just say, meh, we're good, and they dismiss it. Sometimes they turn around and offer a smoke and plea deal. It all depends. That's a very good question. Personally, I think not guilty, but I'm guessing a hung jury. Oh, I think it's going to be a hung jury. There's a couple people in that jury from those questions who are like, yeah, I ain't buying this. I ain't buying this, boss. Zaven's saying they could get a mistrial, put the same shitty case up, maybe get a guilty verdict. Yep. They could retry it. The problem is now for the state, all the witnesses they've had testify are locked in. For the defense, well, all the people they brought in are locked in too, but that's not as big a deal because the defense can neglect to call people. But the state is stuck with that. Now, they might, let's say they find these other guys. Let's say they find these other fucking yahoos who are over there. They could grab those guys and throw those into the mix next time. The state is not stuck with the exact presentation, and they can modify it. You want to see chattel merch? As much as I think that'd be funny, I do not want to get reprimanded for that by the bar. And I think they might at that point. Hopefully those base questioners aren't the alternates. Well, that's the question. C. Souter says, are they deliberating? They've gone home for the night because it's over. It's well past 5 o'clock there. I think they went home already. And as far as dismissing time, I mean, like, I had a misdemeanor assault case. Like, these two ladies had a road rage fight, and the one lady just punched her in the face once, allegedly. My client did. And they retried that. So that's not always guaranteed the calculus a prosecutor will use to retry a case. It all times comes down to, meh, I want to do it because I want to do it. Meh. Sweet is saying to which side? Which side to what? I don't know what you mean to which side. Brittany says, what's the law for warning shots? I mean, warning shots that you're using deadly force and shooting towards people, even in the vicinity of people, is going to be considered probably using force against them. Because if you're shooting in my general direction, I don't know if you're missing me or you're trying to scare me, I'm going to shoot back. Warning shots are generally not a good idea. I never recommend them, especially because, like this situation, you admit you fired your rifle and now there's a dead guy there. They tie two and they can now add those pieces together, where if you hadn't fired, great, they can't tie it to you. Would the bar reprimand you for your mug said prosecutor tears? No, I need to work on that. I will. That's one of the ones I'm going to do. Ron says, how many cases have I done? You mean trials? Felony trials, I've done about 25. Yeah, about 25. Misdemeanor trials, oh God. Most of those are bench trials, but like a gajillion. You said the futures weren't buying it. I don't think they were buying what the state was putting down. They were not buying the state's theory, it seemed like. And yes, Bob with the definitions here. Chattel is a catch-all category, property associated with movable goods. At common law, chattel included all property other than the real property. Correct. Trespass the chattels is what would happen when you stole them. You trespassed on them and against them. This includes leases, animals, and money. Yes, and slaves. That's why the term of enslaving people is called chattel slavery. Using my toes to count? I mean, no, but yeah. Parking ticket cases don't count. I mean, but I mean, if you want to throw that in, like I've had a bajillion. I've had, like trials over, property assessments. The client's like, hey, the county assessor or the auditor has assessed my property way too high and we need to have hearings on this. So you have like many trials and like trials in front of hearing officers. I've had a bajillion of those too. Riparian rights are insane. Yes, water law is very, very weird. They're very, very weird. Next, you're going to say you can't have merch throwing up a Roman. Yeah. RBMK says a night court. There really aren't any night courts around in my area. That was a kind of like an older school thing when you had lots of people working like third shifts. And also just the overhead of running courts has been costing a little more. That said, though, I don't think it's a bad idea. I mean, there's a lot of people who would benefit from a court that runs like not necessarily in the middle of the night, but later. Paul Brackett saying, was her ending of closing judges would reprimand you for? No, that was a phenomenal ending. That was a phenomenal ending. Pima County does night court. Yeah, well, some places might do it. And it probably is helpful for people. They can go work during the day, then come to court, not take time off work or hurt their right things. They have night and weekend court in big cities, right? I mean, like, I worked at the public defender's office, like in Toledo, which was a big enough town, and we didn't have night court, but if there was like a 3-day weekend, we would generally have like Saturday, we come in and do the guys in custody so they weren't sitting all weekend and have seen somebody within 48 hours. That happens. Did I see there's a juror interview from the Nick Mew case? No. But if there is it on YouTube somewhere or where's it at? Because if it is, we'll watch it tonight during well, I don't know how long it is. I'll have to take a look at it. Maybe we can fit it in tonight. Might not. We're kind of busy tonight. We got a lot. Jim, yes, can I give you more information about the riparian laws? Well, I don't know if you want to go riparians. That sounds kind of a little dicey. I used to do guys in custody. Oh, I did the fuck out of guys in custody. Yeah, you heard it. JC Adult says, I forgot it's Thursday. Yes, and because it's Thursday, we've got the 9:30 show coming up, and we're about to sign off in a minute or two, just so I can get ready, because there's a lot to get ready. We got a jam-packed show. That's a shame, says it sounds vanilla. It sounds vanilla. I don't get it. Completely. Right over. Go get some Din Din. No, the Din Din's not the issue. It's getting all my tabs and shit open. Doing show prep. You may have heard of this concept. It's an elite secret that only I possess. I only read what the media said about the 2 Mew jurors. It wasn't very interesting. Oh. Chat wants to know what was on the pizza. Pepperoni. Pepperoni. The finest pepperoni made by Patrick Tomlinson. So, did you see the video of the woman in Seattle who shot? Yes. Tonight, and also that's a neat thing. Tonight, after we do the 9:30 show, if you're new, usually about 11:30, we do the local show. We do a local stream. We are going to watch that lady. I watched it for about 2 minutes while we were watching this real quick. That lady got fucking poleaxed. Holy shit. Just pop, pop, pop. Like, woo. We'll watch. YouTube will definitely get mad at me for that one. We'll watch that on locals tonight. So, all right, guys, that's it. Trimming your bush is show prep. Oh, funny. Sleazy says, wait, what? Well, Monday night, I got in trouble because I showed that guy, the rapper, accidentally shooting himself in the leg with a gun. I'm not going to show that shit live. YouTube will give me another strike, and I don't want that. I officially have an actual strike right now. So I don't need that. I don't need that. So for now, we're going to... Oh, you meant the story. Yeah, these two ladies were arguing in the hallway of the apartment, and she walks outside and just boop, 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 boop to her neighbor. No, what rapper? Plaxico Burress? No. So, not him. So, guys, we are all... No, pineapple's disgusting. It's fucking awful. It's even worse on pizza. So, no, there is no debate. Guys, that is it for this show. We are... Well, we're done, Ski. And I'm going to see who's available out there for you guys. Because now, that would be kind of important to know if there's people live you can talk to and watch. Really not sure. Oh, Robert Gavea is live. I'll send you over to Rob. He's got some good stuff. He's been covering up the Trump trial. So not covering it up, but he's covering. He would be the last guy to cover up things. So I will see you guys later tonight at 9:30. In the meantime, enjoy Robert Gavea. Take care, everybody. Good night.